Who's in the last one?
Good morning. We are live on the record. Today is Monday, May 8th, and this is the Reciprocity Committee meeting for the State Board of Cosmetology and Barber examiners. Give everybody a minute to get on their iPads, and we'll start with our first applicant. I want to welcome everyone here. We have on your iPads, the first reciprocity application is a manicurist license from New Jersey for Bani Saoud. The certification shows an upgrade for a cosmetology license issued initially in 1990 as a manicurist license with 200 hours and an examination. Ms. Saoud provided written explanation about her work experience, and that is on your iPads on page 6. Although she had a cosmetology license, she's only interested in getting the manicurist license in Tennessee, and puts in the statement that her work experience for the last 20 years is with manicuring only. So given that, we would need to approve her. My recommendation is to approve the reciprocal license. It's 29 years, actually.
And she's not interested in the full cosmetic?
She isn't. Given the time frame, I think it has to do with a grandfathering clause. Just like us, what they do if you're working in a shop a certain amount of time is you can upgrade. I'm certain professionally she chose that and said sure, but she never did the full cosmetology. She was just allowed to have it, and so she really has no interest in doing the full thing here. She's done the exam. The short hours obviously would be an issue, but she's been practicing for 29 years.
Make the motion to approve.
Second.
Motion and a second that we approve reciprocity. All in favor? Aye. Motion carries.
Thank you. Next is an application for reciprocity of a master barber license. This is from New York for Franco Benito. Certification shows an apprentice barber with an initial licensure in April 2016. The specific number of hours are not provided, and in New York, each school can determine the number of hours that they go ahead and have them complete before letting them test. So with that, Mr. Benito has provided a letter from the shop where he worked, and that is Henry's Barber Shop on your iPads on page 13. They are attesting that he worked there for 7 years for the equivalent of 1,500 hours. My recommendation is that he take the Tennessee exams.
Did he provide his tax records?
Well, he just started, yeah. So if we go with the barber shop's information, he would have the hours based on their statement, and he's passed the exam, but really has very little work experience. You can approve him or ask him to take the exams.
Make a motion then for him to take both parts of the exams.
Second.
Motion and, excuse me, motion and a second that he take both exams. All in favor? Aye. Motion carries.
Application for reciprocity of an esthetician license from California for Sarah Vaughn. The certification shows an initial licensure in 2004 with only 600 hours, which is what's required in California, and both exams passed. Ms. Vaughn has provided tax records starting in 2012 through 2016, including W-2s. The experience is all in the entertainment enterprise, which is consistent with makeup and other aesthetic services, especially in California. My recommendation is that she be approved for reciprocity.
Add both exams.
Yes, in California they do. The aesthetics is short 150 hours. On occasion we've been leery to even ask them to finish those because it might be hard for them to meet. She's been working since 2012, so she's right about there. But the tax records, if you look through them, are not at a typical salon. They're in the entertainment industry. So she worked licensed doing those things that would be considered legal experience.
The request is for the estheticians, right?
Yes, it is.
Make the motion to approve. Second. Motion and a second that we approve reciprocity. All in favor? Aye. Motion carries.
Thank you. Next is an application for reciprocity of a cosmetology license from Mississippi for Edmund Lee Stamps. Certification shows a license issued in 2016 with hours not provided. Correspondence with that state details that regarding his hours are vague. They are stating on the certification that he was licensed by reciprocity. At this time, we have no other state license, nor has Mr. Stamps listed any other states that he was licensed in on his application. Therefore, the recommendation is that he take the Tennessee exams.
He only has a license by reciprocity, but he can't prove where he got his original from?
Yes. So Mississippi has the same 1,500 hours that we do. We can, if you want, deny it and just ask for additional hours information. It appears that Moore Career College is no longer open. That is the information on the email from that state board. It says the school he went to here in Mississippi has closed. We don't have any information. So what he might be stuck with is not having a transcript.
He'd have a diploma, or he'd have some other record where he took the test down there or something like
The
that.
exam is not the problem because if you look at scores, Mississippi always has them take the exams. The issue would be the hours. So if we treated it like an international applicant where we couldn't really confirm the hours, but we knew the exams were taken, we put them through to take the exams again as kind of historically. So in this case, what we don't have any information is on the hours completed. We can send another letter. We've sent him one asking for the hours and have gotten none. What we tried to do for this particular meeting is get caught up with our reciprocal because some were just sitting there. So we can definitely send another letter and have him wait. We can put him through to test and treat the hours like maybe we would in international. But otherwise, in Mississippi, he's tested, and again, he also hasn't had that license that long.
I think I would prefer to have this one until we get some more information from him.
Second. You don't feel comfortable with him taking the exams?
This didn't seem right in my mind for some reason.
Got reciprocity there, and it's
Why did they grant him reciprocity if they didn't have any record? Maybe there was some other information. Of a double reciprocity thing.
Yeah, I see that, yeah. So, okay, so we have a motion and a second to deny this,
Request.
and request further, more information. All in favor? Aye. Motion carries.
Thank you. Next, we have an application for reciprocity with a cosmetology license from Georgia for Swan Nguyen. Certification shows license issued in November 2016 by reciprocity. Ms. Nguyen is also licensed in Virginia in 2004. However, her application says that she completed school in Georgia. She was presented to the board in June of 2016 at that meeting. I have on your iPads on page 36 a copy of that letter, and at that time the board asked that she take the Tennessee examinations. My recommendation is that we stick with that and that she take the Tennessee examinations.
Take it from the
She
original.
has not taken them. I didn't have a chance to look in PSI to see if she has been trying to take them and failed. I stuck with the letter that was recommended, and the fact that we kind of have conflicting information where she went to school. There was a large gap, so the letter that we sent her that we've not gotten a response on was to kind of understand the gap. If she went to school in 2006, how was she licensed in 2004 in Virginia, and then in the back and forth. And I think that's what we would have evaluated in 2016 and felt that the exams would take care of that. Make the motion she take the exams.
Second.
Motion and a second that she take both Tennessee exams. All in favor? Aye. Motion carries.
Next, we have an application for reciprocity of a license from Florida for Chin Lee. The certification shows licensure in 2015 because Mr. Lee was allowed to let his license go delinquent and expire. That's the reason for that date, and that particular renewal is on page 40. However, his Oklahoma license, where he obtained by reciprocity from Florida, he's also had that one since 2015. That is the actual active license. And so in Florida, even though his application says he has 600 hours, only 240 of those are in the manicuring industry. That full service is the 600, and many applicants make that mistake. And so the correspondence with him kind of contradicts what the state board has provided. Based on his social security number, we believe that the license was revoked in 2012. On page 43, he has correspondence with our board where he says he was not ever licensed in Florida, and yet his license from Oklahoma is by reciprocity from Florida. Again, we're comparing by socials. The document from our system on page 42 shows the note of a revocation in 2012. And so at this time, my recommendation is to deny the license until we actually see proof of schooling, where the school was attended, because that was the issue for the revocation.
I would make that motion.
I'll second that. A motion and a second that we deny the license. All in favor? Aye. Motion carries.
Application for reciprocity of a cosmetology license from Ohio for Annie Ruth Hopkins. Certification shows initial licensure in January of 1980 by reciprocity from Tennessee. Ms. Hopkins obtained her license as a cosmetology/esthetician, which was grandfathered at that time, in Tennessee in 1970, and she held it until 1997. The problem is that her Ohio license is no longer active. She would need to take continuing education in Ohio to get it back. And so her letter is on page 47. I'll leave it up to the board to decide. At this time, she really wouldn't apply for reciprocity. She wouldn't qualify. We don't have an active license. So by having let her license go inactive and invalid, she'd have to retest if she even just followed Tennessee standards.
It really would be just a reinstatement.
A reinstatement, absolutely right.
She originally had the esthetician tag on there from grandfather. If she did retest, would she retain that as well?
No, you lose that. That grandfathering period, once you stop renewing, you just go back to just cosmetology. So the recommendation would be that she take the full reinstatement exam, because if she hadn't applied for reciprocity, that's what we would have put her through to do anyway.
That's really the only option.
That's her only option, correct.
Motion for to retake the test.
Second.
Motion and a second that she take the full reinstatement exam. All in favor? Aye. Motion carries.
Thank you. Application for reciprocity of a license from Florida for Mary Gail Davis. Certification shows an initial licensure in 1982 with 1,200 hours, and in 82 both exams were given. For her proof of experience, she provided 2009 tax records and an explanation that she was on Social Security benefits through 2012. There's no other proof of experience given. The recommendation would be that she take the Tennessee exams.
Make the motion she takes the Tennessee exams.
Second. Motion and a second that she take both Tennessee exams. All in favor? Aye. Motion carries.
Thank you. Application for reciprocity of a cosmetology license from New Jersey for Michael Burdick. Certification shows initial licensure in 1902, which must be an error. Mr. Burdick stated he completed school in 1974 with 1,200 hours in both exams. His New Jersey current certification we went online to confirm is valid through 2018, and that is on page 56 of your iPads, and it too still has 1902 on it, so we were not able to get anyone to correct it. However, we're going by his information, so 1974 would be when he completed school. He also provided proof of work in the industry between 1984 and 2012 as a salon owner with tax records through 2013. I would recommend that we approve him for reciprocity.
Motion to approve.
Second.
Motion and a second that we approve for reciprocity. All in favor? Aye. Motion carries.
Application for reciprocity for a cosmetology license from New York for Kara Moore. Certification shows initial licensure in June of 2012 with 1,000 hours by examination. Ms. Moore is licensed in Arizona by reciprocity since 2015. She has not quite finished the 5 years that are required for work experience, and therefore I was unable to approve her. However, her tax records are from 2012 all the way to a proof of her last payment stub from 2016. My recommendation is that we approve her for reciprocity.
Application, Roxana, it looks like her city and the address information is what a copy thing, or is that? something just missing, or
Which page are you on, I'm sorry?
this is on page 73.
Yes, that would just, we would have it on our records, so we should be fine.
When she finishes out this year, it'll be 5 complete years, right?
November, we're not quite at the 5, or I would have been able to approve her, but she's close enough.
Gotcha.
So you recommend that she be approved for reciprocity? Can't take this one. Okay, I make that motion.
Second.
Motion and a second that she be approved for reciprocity. All in favor? Aye. Motion carries.
Thank you. Next, we have an application for reciprocity of a license from Florida for Rachel Lynn Smith. The certification of initial licensure is from November of 2007. That license is currently active. It's with 1,200 hours and no practical exam. Ms. Smith has provided tax records from 2010 through 2015, but not all of them show that she has worked in the industry, and sometimes we get those. It'll say student or something else. However, she did a letter on page 86 explaining her information. My recommendation is that she take the practical exam.
Do you have proof that she's taken the written one?
Written in Florida for cosmetology always exists. Neither one exists for aesthetics or manicuring, but we're okay with the cosmetology. The practical stopped being given out in 1987. So that's
Motion to take the practical.
okay.
Second.
Motion and a second that she take the practical exam. All in favor? Aye. Motion carries.
Thank you. And we have our last applicant for reciprocity, and she is also here with us today if the board has any questions. This is an application for a natural hair styling license with hours from Guinea for Miriam Seri Sow, S-O-W. I hope I didn't kill the name. The diploma that you have shows that she went to school between 1997 and 2001. She completed her education in hair braiding. She states on the application that she did 450 hours. My recommendation, to be consistent with any applicant with hours that are considered international, would be that she take the 2 exams in Tennessee. Has any questions for her?
Thank you for coming.
Where is she? No.
I thought you would call me first. No, Bonnie?
We're good, okay. So we're good. Yes, I thought she was, so she's good.
So, no, it looked like her. Yeah, I make a motion for her to take both parts of the test.
Okay.
I second. Motion and a second that she take both exams. All in favor? Aye. Motion carries.
Thank you. And we are done. We are going to revisit, Cheryl has a question, so I'm glad that we can do this and we have time. On your iPads, I'll get you the page regarding Mr. Michael Burdick. Let's see if we find him. Is on page 53. So Mr. Burdick has a license as an out-of-state, you just go to Pennsylvania. I'll let you kind of answer the question.
Her last name S-O-U-L?
Yeah, she was the first one.
Oh, she was the first one. Okay.
I had her name wrong. I apologize.
Okay. What page are we supposed to be on?
His application starts on page 53.
We already covered him. Do we have something new? Okay.
Okay, I think we're good.
At the end, I think what we were looking at, Roxana, was at the end
Yes, that is the one that we just voted that she take the exams. I got the two last names when she told me earlier her last name. That's what I did. So we're good on Mr. Burdick. We ended up with 12 reciprocity applications, and that concludes our committee meeting until the complaint committee starts. Thank you so much.
Yeah, that's these days. We do
Good morning. Good morning. We are on the record. Today is Monday, May 8th. This is the complaint committee meeting. I am going to turn this over to the attorney for the program, Sherelle Hooper, and then she'll get us started.
Hey, good morning. This is our complaint committee meeting, and the legal report is prepared by our disciplinary counsels, Pamela Spicer and Allison Renfro. So they will be guiding you all with your questions and et cetera through this committee meeting. Thank you. Good morning, everyone. As you know, I'm Pam Spicer. When you're reviewing the legal report this morning, I have numbers 1 through 21, it appears, and then Allison Renfro has the remaining cases. If towards the back, there are several, as you can see, on the report this month. The represents start at page 15.
That's 15 on the iPad, right?
I'm sorry, page 15.
But not the printed version.
What page?
Which is your last? Oh, the represents?
It's the represents start number 41. I'm sorry, that may be easier to clarify that way.
And it is page 15 on your iPads, yes. We've got a total of 46 cases. Are there any cases that you wanted to bring up to us first?
We are revisiting this month the makeup artists. There was some discussion at last month's meeting about those. We have met with Chief Counsel and the Deputy Commissioner and Assistant Commissioner, and our recommendation on the makeup artists, which I can identify, if you give me just a moment, I'll identify which numbers those are, or Allison, they can help me with that. But as you recall, there are quite a few. Our recommendation on those is closure with a letter of instruction, because there does seem to be some confusion because there are so many different types of persons that either sell makeup, apply makeup, and we felt that it would be appropriate to do a letter of instruction on those. So if you want, we can identify specifically which ones those are, if you want to look at those one more time.
28 through 33 are the cases, and in most of those cases, it was a single complainant that filed the complaint against all these people. They're in a certain geographical area, and the complainant is a licensee listing out people who are not licensed in the area, who are advertising their services on blogs or social media. And those people, when they responded, they said that they had no idea it was unlicensed activity, and that they had called a few institutions saying, I'm just applying makeup, do I need a license? And were told no. So there does seem to be some confusion in the communities. That's why we thought the letter of instruction was appropriate, because it puts them on notice. Now they have no excuse going forward.
What is your follow-up with the licensee who filed the complaints? do you get back to the person who filed the complaint? We do, if I can interrupt. The board office sends, and in this case, complaints are now handled through centralized complaint process, so it's the same for every board, which is what's good. We're consistent. The person that files a complaint gets a letter, kind of a letter explaining the case is closed and this is what was done. Okay. And so in this particular case, the individual would get a letter possibly listing all of the complaints, if it's all coming from one person, and stating that the closure was due to with a letter of instruction.
And I misunderstood your question, but yes, that is correct. And the only one that I have that is a makeup artist is number 15, and that's actually a consumer complaint, so the consumer would have received notice from the board, but we're obviously recommending the same so that we're consistent throughout with closure with letter of instruction. The other four that I would point your attention to are numbers 1 through 4. Those are also closure with a letter of warning, letter of instruction for a recommendation. You may want to read through those for a minute. Those are not makeup artists.
And the other one was 15?
The only makeup artist that I have is number 15, and then Allison has the other makeup artist that she's identified as numbers
28 through 30.
28 through 33.
I'm assuming the letter instructs them that the way to properly be selling makeup services is by getting licensed.
Correct, unless you fall into one of the exceptions. So we can cite the law to them in the letter. Thank you.
Other than the makeup cases, were there any others you wanted to bring to our attention?
I do think it may be worthwhile to discuss 17, 18, 19, and 20. Those are actually represents as well. I didn't notice that on the legal report, all of my cases are together and then all of Allison's. So my represents are in a different location, but they're numbers, not page numbers, but numbers 17, 18, 19, and 20. This gentleman no longer is working in the cosmetology field. He has paid a civil penalty in good faith to resolve 2 of the cases and is asking the board to consider closing the complaints as it relates to the shop because of the civil penalty that he paid towards the other violations and due to the fact that the shop is closed, which is consistent with some of the recommendations that we've made in the past when someone's shop is closed. So when he came in, I felt that it was appropriate to go ahead and obviously accept the consent order and the civil penalty on the individual license, because obviously he may want to work again in the future. He's not working in the industry at all currently.
What if he wants to open up another salon in the future?
He would be, I may defer to the executive director, but I understand he would be free to do that. He would be resolving these cases, all 4 of these cases. He would have discipline on the record as it relates to his individual license, closure as it relates to the shop because the shop is closed. If he applied for another license for a new shop, he would go through the process with the board on obtaining that license.
Yet the penalties were for the way he ran the shop, not his... He paid for the individuals, right? But yet there's a outstanding that he's asking us to relieve because he closed it. So if he closes it and just turns around and reopens it, is that just not maybe a way of skirting around paying for it?
I don't have the exact time it was closed, but I think it has been, his shop has been closed for a while. He has not been working in the industry. I can't give you the exact time frame, but I think it's at least several months, if not longer. My understanding from speaking to him that he was already having problems at the time that all this occurred, and he has decided to get out of the industry completely right now. So when he came in to meet with me, I obviously had to make a decision because the problem was, to be honest, when these were originally presented, they were presented as 4 complaints with an approval of a civil penalty of $1,000 for all 4 cases. So I had to decide he was coming in with $500 to pay towards these cases. So at the time, because of the way it was initially presented to the board, I thought it would be best to take the civil penalty towards the individual license.
However, I just think that we need to be cautious with basically he made you a deal, right? I'm willing to pay half, and they're saying, well, we're not going to fire sale at a half, we'll apply all of it to 2, and he's asking you to leave the other 2, which if he's out of business, I think that's fine, but if somebody's going to stay in business, they got to pay him. So I don't think he should be rewarded for the ability of possibly getting back in business. So is that possibly something that could be suspended and
Flag if he tries to reopen a shop? Because right now, it would be against if he tried to open a new shop, correct?
And we could also close with a letter of warning, which is also a lot stronger than just closure. But also keep in mind the piece of this where we have had other complaints that we've allowed closure or approved closure because closure of the complaint because the shop has been closed. So we do want to be consistent in our recommendations as well. Because I know that I have had complaints where we have recommended closure of a complaint because the shop has been closed. So we do need to be consistent.
I'm fine with closing it. He's paid $500 of the $1,000, and his personal license is free and clear. I just think that, to Frank's point, you send a letter of warning. The barrier to open and close shops is very minimal in this industry, and so I agree that closing a shop only to reopen under a new name 6 months later and avoid the penalties isn't what we're looking for.
So would we all agree to close with a letter of warning for the shop?
Frank's saying, and can you flag it if he chooses to reopen another shop? We can flag his personal license, because he's cleared in essence. If he personally goes to become the manager or owner, that flag would come up with some history. And it would now, because he has a complaint, and we know that it's closed. So we can add something special. I guess I would add for us, for consistency's sake, to determine when we're closing these cases for those shops that have closed, doors are closed when we go and we recommend closure, do we always now moving forward want to send a letter of some sort?
I would think so.
Okay.
I think just because we've always done it the other way, it seems that it's the right way to do it moving forward from an
The shops are
accountability
closing and they have pending fines that... Right.
I would be very comfortable with knowing that's kind of the way of moving forward with that behavior.
That sounds good.
Yes, and we'll keep a note of that and do that in the future.
I mean, in this instance, it said moving suites, and there are several instances where you can easily close one suite and move into a next suite, and that's a...
Close one nail salon and open another one.
Those are the only ones that I have that you may need to look at. I don't know if Allison has any others. I think her main ones were the makeup artist, but I'll let her speak.
And also 45 and 46 in my represents involved the sanitary violation. Last board meeting. This was the 3rd offense the shop had for sanitary violations. However, I went through and itemized each of the sanitary violations since it seemed like the board had some concern that it was a $5,000 civil penalty, $1,000 for each sanitary violation. So I went through, as I said, and itemized the first time they were cited for sanitary violations, here's what was seen. The second time, here's what was noted for the board. Which penalties were assessed to each one, and so this being the 3rd time, there were 5 different issues, but one of them was the first time it was an offense. 3 of the violations, it was a second time, and then the other one was the 3rd time. So the penalties in discussion with the executive director, I thought there's only one sanitary violation that had occurred 3 times, so that one should get the $1,000, but the other ones perhaps could be reduced to a more fine of $2,500 total. And I broke it down in my explanation.
I understand what you did here, and I agree with you. I'm curious to see how further inspections go.
Location?
It's unfortunate we don't have like the food inspectors where this is publicized, because I think consumers would want to know this information. And to add to that, on the inspection sheet at the bottom, we do note when an actual violation has been cited. It's an itty-bitty box. Right. And so, yeah, I get what you're saying. I mean, I know when I walk into any restaurant, I see that number pretty loud and clear behind wherever I'm ordering, but ours are a little more discreet than that, for better or for worse. But yes, I mean, I also recognize the number of cases that we had again about nail infections, and I get that those are very hard to prove, but those aren't going away either.
On my represents on number 41 was another barber that had been found practicing barber services in a shop that was just licensed to do cosmetology, and that shop immediately got its dual license. This barber submitted a response saying he didn't know, basically, and last month the board knocked down similarly situated barbers from the $500 agreed citation penalty to $100. So I thought that may be appropriate for this individual as well. And the shop itself is number 42, and it had been previously cited for permitting an individual to work who was not licensed and for not having barbers work there, and it immediately got its dual licensure. And the individual who was working from he basically fake license that looks legit, and so.
When are the dual licenses? When is that?
We will discuss that in greater length almost with the new business. The rules are already on our website for everyone to see. They go into effect June 7th.
And that includes the dual license
That includes
shop.
the dual license shops as well. And so those will be, we're working on the technology to get that done. Since we're asking about it, we're going to send out information to the shops, letting them know that it's on them to decide to pursue this. We don't know which shops have, let's say, skincare and manicuring or Cosmo and Barber, which are the most common. So we'll send all that information out by right after June 7th. They should be able to do some of that.
And apply and...
Yes.
Okay.
And we did file a stay request for the rules related to the fees. So those, if that stay is granted, will go into effect June 30th. So maybe June 30th for some of the dual shop related items as well.
Well, that will hopefully solve a lot of this confusion on who can work where. I don't have any other questions. Did you guys?
I have one unrelated. I mean, I feel like we're all on the same page with the recommendations, and I'm certainly in support of them. Talking about who can work where and do what, someone in my area called me knowing I'm on the state board and asked me a question I couldn't answer, and I don't know if now's the right time for it or not, but I certainly don't want to forget. So I'll present it, and then if we need to wait till later, just let me know. Can a natural hairstylist license do shaves?
No, nothing in the curriculum touches on shave, cover shave. There's no chemical hours there at all, and definitely just those physical hours that involve dealing with the hair on the head.
But I didn't want to go on record with misleading.
And the legislature, the safety razor is for specifically for cosmetologists.
Like natural hairstyling is
not included under
in
that.
essence, cut, although they can definitely trim and do certain things, but the shading with the natural, with the safety razor was added to the cosmetology hours.
Only. Okay.
Now, can the cosmetologist with a safety razor shave a face?
Our field inspectors were specifically trained on, what they would start seeing with that safety razor.
So if there are no further questions, we need a motion to adjourn.
Make a motion to approve the legal report and adjourn.
Second.
All those in favor?
Aye.
Thank you. Thank you. Maybe we'll break until 10. Thank you. Good morning. Yes, thank you.
Good morning. Today is Monday, May the 8th. This is the State Board of Cosmetology and Barber Examiners meeting, and we are starting the full meeting. And we are actually streaming live now to the general public, so that is great news. I'm going to welcome everybody here. Chairman Gilman, I'll turn it over to you.
Thank you, Ms. Roxana. It's good to have you back. We've missed you, and
Thank you.
We appreciate the hard work that Glenn has done for us, and just glad to have the whole team back here today. We'll call this meeting to order, and at this time, I think we need to have a roll call.
Thank you. Ms. Kelly Barger is not here today. Ms. Anita Charlton? Here. Ms. Charlton is joining us through telephone conference. Nina Coppinger? Here. Bobby Finger?
Here.
Frank Ambusa?
Present.
Ron Gillihan?
Here.
Brenda Graham is also not here. Ms. Wybette Granger? Judy McAllister? Present. Patricia Richmond? Present. Mona Sappenfield? Here. Ms. Amy Tansley? Here. All accounted for. Thank you.
Thank you. At this time, we will recognize some of our guests. It's a shame we don't have many people here today. So, folks, it's good to see all of you out here with us. We appreciate you coming down to participate in your board meeting. I believe we probably have some schools here today, do we not? Could we have someone from each school stand up and tell us who you are and what school you're with? Oh, thank you for coming. I know it's a drive. Hi, good morning. Good to see you again. Thank you for being down here today. Yes, ma'am. Well, TCAT schools, thank you for coming too. Folks, we are glad to see all of you. Hope you learned something today, and we encourage you to always participate with your boards, and we wish you all the best in the future in this industry. Okay? We would need to move to the approval of the April 3rd, 2017 minutes. Are there any additions, corrections, or deletions?
Make a motion to approve.
Second.
We have a motion and a second to approve the April 3rd minutes. All those in favor say aye. Excuse me, hold that. Ms. Roxana, because she's attending my conference, we have to have a roll call.
Yes, we do. Given this, that we only have one person, Ms. Anita Charlton, if you're there, do you approve the minutes or have any changes?
I approve the minutes.
Is that okay? Yes.
All those in favor say aye. Aye. Motion carries.
If I could answer the minutes, this particular time you passed around the January meeting minutes that needed to be signed. That was the month that I wasn't here, and then also the March in signature form, and then for the last time, the April. If the board is okay, we're going to change it to where you won't have to sign them in ink as you motion them in. That is the official record that the minutes have been reviewed and agreed upon, and will be consistent with other programs to where we won't actually have to sign. I'll miss seeing your signatures, but it'll make the process a little bit smoother. So as of next meeting, we will post them the minute the meeting ends without the official actual signatures. Thank you.
The next item that's on the agenda this morning are legislative updates.
Yes, good morning. My name is Sherelle Hooper for the record, and I wanted to go through the legislative updates with you all. If you look on your iPads, this is under the presentation section after the title page appeared before the board. And we're going to start with House Bill 0030, and that is also Senate Bill 0032, sponsored by Representative Lawler and Senator Harris. And under this bill, barbers would have the ability to perform services in a residence from residences of persons who are actually ill to all residences regardless of health of the person, and this would require a residential barber certificate to provide the residential services. So it's amending that previous law that only allowed them to perform services in a person's residence when they were actually ill. And the history shows that this was signed by the governor on April 7, 2017, and it is now law, and that's under Public Chapter 102. The next iPads is for House Bill 31, Senate Bill 33, and that's sponsored by Representative Parkinson and Senator Harris. And under this bill, it deals with the same portion of the statute as the previous bill as far as where services may be rendered when a person is ill. And it authorizes the performance of services in the residence of any person who is suffering from an actual illness or disability. So it changes the language from actually ill to suffering from an actual illness or disability. And the history shows that this one has not been moving lately. In the Senate, it passed on second consideration on February 1st, 2017, and it was on the calendar for the Business and Utilities Subcommittee in the House in March, and it was taken off their calendar March 21st. So that's the latest update on that one. And that's the amendment following that on your iPads for 3230, the one we previously discussed. So now we'll go to Senate Bill 797 and House Bill 710. And that was sponsored by Representative Whitson and Senator Dickerson. And as introduced, that bill removes certain restrictions on the right to practice cosmetology and natural hairstyling outside of shops or schools by persons licensed in such professions. And right now in the House, that is on the subcommittee for Finance, Ways, and Means as of May 3rd. And then in the Senate, it's passed in the Senate as amended. And so pretty much this bill's with the House right now.
Well, those two, this pretty much the same thing. One's for Barber and one's for Cosmetology.
Let me take a look.
Ms. Allen, I'll take a moment. If I could get you to mute your button, and then we'll make sure to get you to unmute to vote, just so we don't... Okay. Thank you, ma'am.
Thank you.
Thank you.
It's very similar. So what it does under the cosmetology portion is it allows the services to be performed in the recipient's residence, short-term residence, or place of business. So it's very similar to the one under the Barber section, except this does not require a special certificate like the Barber bill does, which is now law.
So this is just a notification to us that it's law, right? I mean, it's not up for discussion, or there's nothing that can be done about it.
If the law has passed, then that is correct. It's done if we've got the public chapter.
Yeah, if it's passed. Now, the one, Senate Bill 797, House Bill 710, that one is not showing that it's been signed by the governor yet, so that one is not yet law at this time, but it's on the subcommittee's calendar for Finance, Ways, and Means, and that's as of last week. So it's headed that way for discussion with that subcommittee.
It's just more of a notification to us, or is this up for discussion and potential pushback if
while the session is going on, we've done this for the years that I've been here, we want to make sure to update the board on everything that's being presented that touches the industry. Of course, during the time, you're welcome to do your research, keep up with them, that kind of thing, but anything that is still current that we've done from the beginning, which would have, possibly in January to now, is on your iPads now. By the time we meet in June, the session will have ended. So they either will have all passed or be pulled. And so definitely with Sherelle's experience, and she kept up with these while I wasn't here, I want to make sure that any questions you have, you can ask her. She's going to present them all. I think a couple have passed by public chapter, but the rest are still in the pipeline.
So, just in layman's terms, so barbers and cosmetologists can go to someone's residence and cut their hair and perform their services. Pardon? Without them being ill. Just anybody.
Licensed, yes.
So,
It has already been passed for the barbers and has not been signed by the governor on the cosmetology and natural hair, right?
it's right, his pen's right there ready to sign.
So are the manicures and estheticians included in the cosmetology umbrella?
It's the statute.
Okay.
It's not contrary to the oath that we took when we came on this board, was to protect the health and safety of the public. Because to me, this has got zero protection to the health and safety of the public, because there's zero criteria on what you have to do to go to somebody's house. Is that environment, or the tools going into that environment, sterile and clean? Who's responsible for insurance? I mean, what if something's to go wrong? Who gets sued?
As far as, just so you all know what is actually in the legislation, with the barber certificate, they have to get a special residential certificate, and they do have to have an initial inspection of their equipment at the beginning of the licensure process for that.
But you were saying that's not the case for cosmetology.
That's correct.
Right. So why, I mean, to me, the inconsistency there is a red flag, because one sort of at least upholds or is in alliance with the oath, and one has got zero to do with it.
I've voiced my opinion, which was worth really nothing, to one of my state senators about this when it first came up, and his argument was, you can have home health nurses go into homes. Now, how are you going to, I mean, that's, you got to worry about safety with that, and that was his argument. And then again, you have to worry about, I don't know, I think there's so many loopholes, like, are people going to report their income when they do that?
No.
But they didn't really seem to care. They just went ahead and it went through the process to become law. But then what would keep someone from not going through the steps of having a shop at their house and just having people come to their house? It's a residence, and nobody's going to say, wait a minute, this is your residence, not the client's residence. I don't think that's going to happen. So why would somebody go to the all the fees and all the expense to set up a shop with a separate entrance and all that we require in their home if you can just do it in your house, like in your living room? I don't know. So, we had this long discussion, but his argument was that's the way that everything's moving. It's progressive, and people want, convenience. People want you to be able to come to their house, and I don't know. I mean, frankly, I'm not sure a lot of people would want to go to somebody's house to cut hair, so that's going to cut out some of it. I mean, I think professionals really would prefer to have, I'm not in the field, but I think they would prefer to have a shop where everything is set up and they can do it, I mean, who's going to clean up the mess when you go to somebody's house? There's just so much to it. I don't know, but yeah, it's been cranking through the whole system, and there's nothing we could do about it.
The home health nurses
John
are
went and
trying.
talked to him about it.
I spoke with Senator Tate, and he was really impressed with, your presentation to them.
Oh, wow.
Yeah, he was. And he basically said the same thing, that they're moving towards the deregulation, and people wanted the convenience, and they felt like it was moving along with the sign of the times. So he wanted to know how that would directly affect me as a, I have brick and mortar, I have employees, and so I explained that to him. It didn't seem to have any impact or effect.
I could add, thinking back to the January meeting, the board voted on Chairman Gillian to go and speak, and he did a phenomenal job. I mean, from the deputy commissioner to the assistant commissioner, he did a phenomenal job representing all of you and your concerns. And he answered all of their questions, exactly what you were told came up, all those points. I just want to remind us, the individual still needs to have a license, so that doesn't change. They need to pass the exams. And just like we know now, some choose to work unlicensed. That will probably happen. They definitely can work still at a brick and mortar, and we've heard from shops that say, my folks are still going to come to my shop. They come for the experience, they come for the whole thing. So will it have an impact? We will see, without a doubt. But for the home, if the individual chooses to provide the service in their home and it's not licensed, that's not what either of these bills do. This is the individual going to the person's home.
But the definition of ill is what?
Well, it isn't. I mean, it doesn't matter. They keep it up. Yeah. They can go to anyone's home.
I sneezed twice this morning.
You don't have to sneeze. You don't have to sneeze.
You don't have to be ill.
No, you don't have to be ill. Right.
Well, the law previously was stated, required that if someone was ill, then there was an exception that you could go into the home, and now they removed that provision. Requirement.
This really puts me in a compromised integrity position of 45 minutes ago, we're fining somebody because they didn't keep their place clean, and they get fined. So because they want to do things right, have a brick and mortar business, pay taxes, have insurance, do what it takes to be a legitimate business, and then we're opening up a can of worms on the other side that says it's a free-for-all, do what you want, it doesn't matter if the place is clean, doesn't matter if you report the income and pay taxes. It kind of puts me in a position of who are we and what are we really representing? First of all, it's coming from top down. We really don't have much of a voice to begin with. And then when it gets slammed through and it becomes law and we're told this is what we have to govern and vote on, it's hard for me to sit here and feel like we're representing the people of Tennessee and the politicians and barbers of this state in a way that I can feel comfortable about. This is extremely concerning.
I feel that way too. Kind of like our hands are tied and it's just thrown at us and that's passed, and then they say, you've got to make the laws for this. It's passed, so that's what we do.
Look, I'm all about being progressive and change with the times. I mean, I run my business that way. And one of our core values are, change is inevitable. It's going to happen. But when it's going backwards, it's not real good. And this is something we tried to get away from 20, 30, 40 years ago. And here we are going right back to it. Makes one feel very irrelevant.
At this point, it is what it is, and time will tell. I mean,
I think it leaves us almost in liability because we are making decisions on people's practices and their establishments that impact them in a way that if you just, pack your backpack and go to somebody's house, you can go all day long. You can go all day long and charge them money. So I think that those people who are impacted by our decisions based on the original law have, just opened down on liability towards us, and that's a very uncomfortable situation sitting as a board member to just open up a can of worms for one lawsuit after another lawsuit. And I believe that's what the legislature has done this year with these, and I express that to Senator Tate, that we're just sitting ducks.
So, right, Senator, basically these laws have been passed and one is waiting for the integer. And then do we come and re-regulate these laws, and we have to, make sure they are operational enough to protect the
the public and the professional? Is that where we are right now?
So for the barbers, there's a little bit of rules that, or pieces to the law that were added. We will have to make sure that those are in place. For the cosmetology, it just gives them the option to work in the shop or go to the home. Do we regulate it? The issue would be obviously if we had a complaint that said someone came to my home, pretended, said they were a licensee, but then destroyed my hair color or whatever, and they're filing a complaint. We regulate that. That would be an unlicensed service. And that happens now, right? There's no real change.
But we're not encouraging it now.
Correct.
But we don't have any regulatory authority on someone who's not licensed, who's not compliant, and who's cut hair.
Which is breaking the law. I mean, that's...
We just don't have any. But we will on that licensed, on that licensed person that went to the home and was unprofessional or didn't follow what the statute says they need to follow, which is going to be carry your license with you. You know, like you would post it in the shop, it's at least have your license on you.
And we would handle any case of unlicensed activity the same way, even if they went to someone's residence. So if someone unlicensed went to a residence, we'd be able to open a complaint and issue a civil penalty similarly to the way that we handle cases now. And we will be charged with coming up with rules related to these laws that pass. Some of them will require rules, some of them don't, but definitely with the Barber side of this, we definitely will need new rules, and more than likely with the cosmetology side of this, we'll need rules associated with this as well if it ultimately becomes law.
That's the answer to the question I was asking, so I guess fellow board members, we know that it's coming and we know that we're going to have to make these rules, and it's our head, you know, so there's something to think about when they come about.
Will it be a fair assessment to wrap this up so we can move on to say that it's probably a unanimous position of this board that we are and were against these provisions, and we see that they're fraught with all sorts of dangers and risks. And as I specifically told the members of the committee as I spoke to them, who's going to be responsible for the lawsuits that potentially could come from this and the complaints that come from this, and it really has to go back to them, I believe, at this point.
I'd just like to point out one more thing before moving on. That's the lack of correlation between, we're talking about a dual license coming up in June to where it becomes one, right? Cosmetology and Barber. And here we are putting new rules into law where the barber is having a completely different set of rules than the cosmetologist and vice versa. I mean, I'm thinking from just a business acumen standpoint, 101, that's upside down in itself. All right, let's merge it over here, but let's do all these things separate over here. I mean, I would think there's...
Since I've been active on this board, Senator Pat's been trying to get it cohesive and get everything, and just so much time is spent on that, and expense to this department with the attorneys. I'm just merging everything together, and I think it's really irresponsible of the legislature to just start tearing it apart.
Absolutely.
They have just made years of worthlessness to our efforts.
We had a couple more bills go through, Senate Bill 1303, House Bill 1338. This was the one related to domestic violence education, the 1 hour requirement. Right now, shows that failed to pass in the Senate. So that's the status of that one.
Wait, before, are you moving on?
You can ask a question.
So, when does that become effect?
That one failed to pass in the Senate, so it doesn't look like that one's going to go forward.
So, Nina, are you referring to?
The 1 hour domestic violence course?
Yeah,
it's not going to pass?
Does not, no.
Okay.
It failed to pass in the Senate on May 3rd, so.
I had trouble with it, the language that it required that course. For anybody that's sitting out there, there is I saw online, I can't believe everything you read online, but I saw online a program called Cut It Out, and it builds awareness of domestic abuse by training salon professionals to recognize the warning signs of abuse and safely and confidentially refer victims to local resources for help. I guess you'll find out in your profession that people talk a lot while you're fooling with their hair. And so that Cut It Out program sounded like a good thing. I don't know if you want to check it out or whatever, but I had trouble with it saying required, because then we would have to make sure everybody did that when you renewed your license or when you got your license, and so that just puts another burden on us. But it sounded like a good thing that if I were in the profession, I would probably want to know a little bit about the signs and some information about domestic violence, because people do talk in your profession.
And also, just to add a note that Chicago actually put into effect January 1st, where through Cosmetology renewal of license, they're doing the domestic thing as well.
I think we had two more bills that were related to our programs. The next one is House Bill 306. That's Senate Bill 1194, sponsored by Representative Hawk and Senator Norris, and that's the one that does away with the shampooing license. That was signed by the governor on April 28th and became a public chapter 227. So that's now the law that the shampooing license is not required if you're solely engaging in shampooing.
That currently active? I mean, could we hire somebody tomorrow without a license?
28th. That's April 28th that went into effect.
Thank you.
What's the public chapter number for that one?
227.
Thank you.
And the final bill that we wanted to discuss today was House Bill 326. Let's see. Senate Bill 1217, sponsored by Representative Hawk and Senator Norris. This was the bill that just dealt with administrative procedures and essentially gives commissioners and chief executive officers of administrative departments under reg boards the authority to review and either approve or veto any rules that would constitute unreasonable restraints of trade. The governor has signed this into law as of April 24th, and that's when it became effective, and it is Public Chapter 230. And that is all I have for you as far as legislative updates, so thank you all for your questions and concerns.
Thank you. We appreciate your hard work. We are now up to new school applications, I believe.
Thank you. This month, we actually have both of the applications that were attempted to be presented, not going to be presented at the meeting, so we have nothing else under the appearing before the board. We will probably have both at the June meeting, but the information was provided after the agendas were sent to you and the deadlines. Yes, we're going to skip directly to the administrative piece, and if it's okay with the board, since we have the our legal attorneys regarding complaints, if we could go ahead and do the complaint information, see if anyone else on the full board has any questions to ask. Both Pamela and Allison are here, and then we will wrap up and motion that and get back on track.
Thanks for being here today.
Good morning. How is everyone? We reviewed the legal report this morning in the committee meeting. There was a recommendation to approve the legal report as is, with the exception of, let me find, on numbers 17, 18, 19, and 20, those are represents.
it was recommended that we change the recommendation to closure with a letter of warning instead of closure that had been initially recommended. That's the only change on the legal report.
17, 18, 19, and 20.
Correct. That's 4 complaints with one individual, one shop.
In this instance, just to add context, when shops have closed, we've dropped the fines against those shops if the shop has been closed. In the past, we've just sent a letter or a closure notice. Now we're going to send a letter of warning that just states that there are still fines against the shop, correct?
There wouldn't be a fine against the shop
Because the shop is
because it's
closed.
closed with a letter of warning because the shop has been closed. We had some discussion about this in the committee meeting. The issue is for purposes of consistency. In the past, when a shop is closed, we have come back in and either represented or on the initial representation, closure. Now, going forward, what we want to do is closure with a letter of warning. There wouldn't be a civil penalty because the shop is closed, but there would be a letter of warning, which obviously holds a little stronger zing to it than obviously mere closure. And in this particular instance, the gentleman did come in and met with me and paid, it was a $1,000 civil penalty for all 4 cases, so he did pay $500 at that time. I made the decision to put those towards his individual license because the shop was closed and because of what this board has done in the past related to shops.
Do we need were there more, or do we need a motion on this?
May I ask a question about that? In a situation like that, if the owner comes back later to open another, is that flagged?
We had some discussion about that, and Roxana can speak to it as well, but yes, the discussion was there would be some sort of flag in the system when they came back in to open another shop.
Our current system is able to identify the licensee if they are a manager of the shop as well as an owner of the shop. So it's one of the great things that we got out of the new system, for our shops at least, that we can see that. And so when that individual goes to purchase and be the owner of the shop, we'll be able to see that at that point, or a manager, and look closer at it. So we'll add a flag. And the letter of warning also has some significance as opposed to the closure. So both of those will be seen. Thank you.
If there aren't any other questions, then we would need a motion to approve it.
The motion to accept.
We have a motion to accept. Do we have a second? Second. We have a second. All in favor say aye.
Aye.
Aye. Motion carries.
Thank you.
Thank you.
We will go back on your iPads. We are on page 28, and at this point, we're looking at our applications for examination. You have before you applications for examination for Shaina Harvey, Miss Dallas, Betty Small, Vandalin, and Lisette Taylor. These applicants have felonies within the last 3 years or are currently incarcerated. The request is for them to take the Tennessee examination, and this is presented for your approval. The required information, disclosure from the student, and a letter of recommendation have all been submitted. The board's historical approval is for an agreed order for a probationary period of 2 years that is prepared by legal. I will let you review everything and see if we have any questions or need to extend any of those. Thank you.
I make a motion that we approve with a signed agreed order and a 2-year probationary period. Second.
We have a motion and a second to approve with 2-year signed agreed order. All those in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you, Ms. Charlton. We have everyone. On your iPads, next we have our applicants to test as well. These are out-of-country applications. The first is an application to test as a master barber with hours from Iraq for Sakvan Abdullah. Mr. Abdullah provided translated certifications, a certificate showing that he completed 1,500 hours in September of 2010.
I make a motion we approve him to take both exams.
Second.
We have a motion and a second to approve to take both exams. All in favor say aye.
Aye.
Motion carries.
Next, we have an application to test as a master barber with hours from Jordan for Farhan Afukana. Mr. Afudaka, pardon me for killing the last name, provided translated certification of completion showing 2,500 hours and that they were completed in September of 2013.
No problem on the last name, happens to me every day.
Both exams.
We have a motion and a second to approve for both exams. All in favor say aye.
Aye.
It's unanimous. Motion carries.
Application to test as a cosmetologist with hours from India for Seema Bohani. Ms. Bohani has provided translated certificate of completion showing 2,010 hours were completed in March of 2004.
Make a motion that we approve her to take both exams. Second.
We have a motion and a second to approve for both exams. All in favor say aye.
Aye.
Motion carries. Unanimous.
Application to test as a manicurist with hours from Vietnam for Than Huy. Mr. Huy has provided translated certificates showing he completed 450 hours in November of 2016. Tennessee requires 600 hours for manicuring. Mr. Huy still would need to complete 150 additional hours before he can test. Recommendation would be that the motion take that into account.
That is correct.
That is correct.
The recommendation would be that he take the additional 150 hours before we would send him to test. And that would be the motion that I would make.
Second.
Motion and a second to complete the 150 hours and then take the test. All in favor say aye.
Aye.
Motion carries.
Thank you. Next is an application to test as a manicurist with hours from Vietnam for Huy Nguyen. Ms. Nguyen provided translated certificate showing she completed 600 hours in March of 2016. She held a manicurist license in Tennessee between 2012 and April 2013, which was suspended until she could provide proof that she met the requirements. And so at this point on her let me see. The hours that you see after the suspension on page 68 show that in 2016 she would have gone back to Vietnam and complete these hours.
So she has all of her documentation there, and you have all that.
We have the international documentation like we would for others to be able to accept those hours that are after the license that was suspended. And so if the board agrees, she'd be able to test.
Make the motion for the test.
Second.
We have a motion and a second to allow her to take both portions of the test. All in favor say aye.
Aye.
Motion carries.
Thank you. Next, we have an application to test as an esthetician with hours from India for Mahaden Patel. Ms. Patel provided translated certificate of completion showing 3,360 hours completed in 2011. The Kadambari Beauty Parlor provided a training document showing training in advanced aesthetics. You have all her information before you to be able to approve her to test or request more.
Make a motion we approve her to take both exams.
Second.
We have a motion and a second to approve for both exams. All in favor say aye.
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 Motion carries.
Thank you.
Next, we have an application to test as a master barber with hours from the Dominican Republic for Francisco Reyes. Mr. Reyes provided translated certificate of completion showing 1,500 hours were completed in May of 2013.
Make a motion that we approve him to take both barber exams.
Second.
We have a motion, a second, to approve for both exams. All in favor, say aye.
Aye.
Motion carries.
Last one within applicants to test is an application to test as a manicurist with hours from Vietnam for Yan Truong Tran. Mr. Tran has provided translated certificate showing that she completed 800 hours in January of 2017.
Make the motion for them to test.
Second.
Is she, Russ?
It's he. I apologize. Yes.
We have a motion and a second.
I was just looking for when we were in the nail salon, that's all.
To approve for both tests.
Motion, I apologize. Thank you.
All in favor, say aye.
Aye.
Motion carries.
Thank you. And we did have a lot of international applicants here shortly. Sherelle has worked very hard on the process, so we will turn it over and kind of put all those pieces together for you. I appreciate your patience. Okay, we are now on the miscellaneous section. We have first on your iPads on page 86, appearing before the board, is a request for a teacher training program pursuant to Rule 0440-01-.11. Ms. Doria Caldwell is asking for consideration of instructor continuing education within manicuring. So I'm going to ask her to stand before you and answer any questions you have. Just make sure the board is ready. Good morning.
Good morning. Thank you for coming in today. Just a minute to read your file here.
What is this a proposal for, Roxana? This is to do a continuing education instructor course?
Yes, the only mandatory continuing education we have right now would be for instructors. She is an instructor and her specialty is in manicuring. And so any questions that you want to ask her after that are, you have plenty of time, but she's got her information on pages.
So this would specifically be an ongoing education for manicure instructors?
Correct.
Or anyone at cosmetology instructors?
We would be approving the continuing education for the instructors, but that's not to say that she couldn't teach.
Right.
Or students or in the school, and she'll explain her experience. She actually is doing some of that.
It's a good program for the continuing education for manicure instructors.
Is there a separate manicure instructor license?
There is. We don't have a lot, but we do have probably 30, 40 that are just within manicuring.
I think this is a great idea, especially with me living in Memphis and being in the beauty industry there. I've heard a lot of people ask for this, so I think it's absolutely wonderful.
Got other cities in the list too, like in Knoxville and some of the other ones?
For a teacher training class, we have to have the curriculum and the
Correct. I think on page 89 of your iPads, that's what we would include probably, yes.
This would be how many hours does the ongoing education have to be?
Has to be 16 hours.
Just to be clear for me, this is just for a manicurist instructor's training course, not a full cosmetology or barber instructor training course.
It is for manicurists, However, the cosmetologists and the barbers, their license encompasses our license. So absolutely, they're more than welcome to attend because I've been demoing for some of the cosmetology schools that are in Memphis, and that's what I'm getting. There are a lot of new trends in manicures for male technicians that they're not getting a part of. And because I'm in it every day, I do work. I am still in the business. I have a very healthy clientele. I can teach those things, and now that I have my instructor's license, I absolutely can show them all of the new things that we're doing. But in the CEU classes or instructor classes that have been going on, they're saturated with hair and barber, which doesn't benefit us as instructors, and I'm paying my money for continuing education in something that doesn't benefit me. But this will benefit us. And it benefits them as well. It benefits our specialties, if you think about it, because what about that cosmetologist that wants to step down? She doesn't want to do hair anymore. She just wants to do nails. Her license encompasses it, but she has had no training on what's new and what's upcoming in the industry.
A cosmetologist attend this one
If it is approved, as long as it's 16 hours, that statute that I read, 0440-01-.11, breaks, it has to include teaching methodology, and it breaks down as long as Ms. Caldwell sticks to the breakdown of what's covered in the statute and fits it into 16 hours. She can specify the rest of the hours to be just manicuring, and master barbers could attend it, so could cosmetologists, so could instructor in just natural hair or aesthetics. It would open it to any instructor.
Well, I have a question, just for clarity. Is this a continuing education for instructors only, or are you doing this to try to provide hours for manicurists?
No, not hours for manicures yet.
Yeah. I'm like, we offer a whole lot of hours.
I think this is awesome.
Do you have teaching methodology in
I'm sorry?
Do you have the teaching methodology listed in here?
I did not list that in the curriculum classes, but absolutely that will be included.
You do these classes, Ms. Caldwell, in a school or in your facility? It's quite a bit of equipment you're teaching on.
At this time, I would do this one in my facility where I work. The classes would be very small.
Where are you located in Memphis?
I'm sorry?
Where are you located in Memphis?
1572 Assey, East Assey Road. It's in south area of Memphis. It's a beauty shop, full service salon, but I'm the only male tech that's in there.
Go ahead.
To add to what you said, I also wanted to be able to provide them online, and I know that the videos would have to be submitted to you all first for approval, but that also will help because you all have already approved for online CEU classes, and that will give them the opportunity to do them at their own time, at their own pace, because this is a lot. Manicuring is not manicuring anymore. It's really an artistry to it. There really is a technicality to it that I believe our board is, we all are kind of missing on what we do. It's not to downplay or downgrade cosmetology and the 1,500 hours that they have to get. They absolutely know nothing about what I do and what I have to provide to my clients. These classes will give them that. These classes will explain that. And as you can see, just basic manicuring and e-filing, it's a 2.5-hour class. And this is something that I've actually sat down and demoed for another cosmetology school. And I mean, it really took time for me to give them the basics of how to do it, for me to explain to them that, healthy nail care is first, sanitation goes along with it, explain the process, making them be consistent with the process so that they're not messing up somebody's nails or actually breaking the process of sanitation. So it's a lot to it, and I think if they were able to see it on video, some people, they can rewind it, they can go back, they can stop it, they can listen to it again, instead of just sitting in the classroom and then once it's said, I missed that. Can you repeat that? So you got that video thing too. So I appreciate the fact that you have put CEUs online, and I want to add that to it if at all possible as well.
So with that, be enough to satisfy, we've asked others that have applied for this, who's their backup? Because I believe in you. I think you're doing a great job here, but if, you sign up all these instructors, what happens if something happens to you? You just going to plan on rescheduling, or do you have someone that works?
I have some other instructors that need to help me. I do.
At this point, I think what I've said here is not just an instructor training program in order to offer licensure that would require a school for. This is to offer continuing education for already licensed instructors. A concern that I have, just to be clear for you, so you really understand, is that when I look at this, and I think it's a wonderful program, and I'm certainly be in favor of it, but I want to remind you that a teaching CEU program is essentially helping to retrain or reiterate some of the teaching methodology for instructors. This is not teaching a craft. This is not a barber teaching a haircut. This is not you teaching someone how to do nails. It's you assisting that instructor in learning how to better teach. That is the purpose of these type programs. And when Ms. Roxana mentioned the teaching methodology, that's what she was referring to. So it has to be geared around that, not just teaching any technique to somebody. The technique is perfect so long as it's a teaching technique. How do I teach this instructor how to better communicate the idea and the practicality to do it? That's what the CEU programs are really about. So I think you've got a good program as long as that's being incorporated there. Now, the issue with adding the online version, I think that would need to be a separate presentation. Okay.
Only other thing, if I could add, that came to my mind as I was explaining, your master barber instructor or your cosmetology instructors, because they can do nail care or full-on manicuring, pedicuring, and so forth, they would be able to count this. I'm struggling as we talk about that. I don't think an esthetician instructor or a natural hairstyle instructor would be able to get their 16 hours, even though it's on teaching methodology, because she is going to be specifically covering some hours in a trade they can't do. So, they definitely could take the session. They just couldn't count it, I believe, toward their 16 hours because of that, because they can only teach the discipline they're allowed to do. So.
Do you have any other questions?
I just noticed that you have your master's in business management. Where did you get that from?
I actually got it at ITT online before they closed. Way before they closed.
Congratulations to you for being that aggressive in the academia world. So it's good to have somebody like you representing this profession and passing on that education.
Do you have a motion?
I'll make a motion to approve as long as she includes her teaching methodology in it. A second.
We have a motion and a second to approve. All in favor say aye.
Aye. Aye. Just submit that to Ms. Roxana for her to look over.
Motion carries.
We also had Ms. Charlton voting, so we're all in agreement. At this time, we don't have any dates or times, as long as the board is okay with that. When we get them, we will make sure that a board member is selected to participate in our session so that we have a full view.
Question. So when I get these same classes or with the teaching methodology as well included, to present them for online will be a different time and a different session, right? Okay. Thank you.
Good luck. Congratulations.
Congratulations. Thank you. Next we have on your iPads on page 90 and 91, this is a request from instructor Anya Davis for an extension of the required continuing education hours. Ms. Davis is timely in asking for her request pursuant to Tennessee Code annotated 62-4-114A2, where an instructor may request this waiver for one time as long as everything has been met. Ms. Davis was in an automobile accident, and because of financial issues, she will not be able to attend the session and would like an extension during the year of 2017.
And she's not had an extension prior?
Has not, and she actually doesn't expire until May, so she would have been able to not even ask for it, but she doesn't have the funds available to do the online yet, so she wants that added time, and she's not teaching now.
I make a motion that we grant her the extension.
I wanted to just say, I know this particular woman personally, and I do know of this accident, and it did put her in a very financial bind. So, sure, we would greatly appreciate this.
I second that.
Thank you.
We have a motion and a second to approve. All in favor say aye.
Aye. Aye.
Motion carries unanimous.
On your iPads, we actually did a category revoked licenses, so the next few following that area. First, we have a request for a manicurist license for Dow Nguyen. Ms. Nguyen passed her practical exam in March of 2017. She previously held a license which was revoked in November of 2016 because she did not obtain her education as required by Texas law. She then completed hours in Tennessee in March of 2017 through the apprentice program and is now requesting her license. Ms. Nguyen, like many other applicants, has answered the attestation question about having had a previous license in Tennessee incorrectly. I'm mentioning this, and it's similar to all of them, to see if the board wants me to open complaints against all these individuals. Basically, she's attesting that she's never held a license here, and she in fact has. It was revoked.
Here we go again.
A question about this one. Did she go to school all over again, or what did
Yes,
she do?
206 is a school in the Middle Tennessee area, and she did. She completed all the hours, the program that they've selected, and I think the next 2 or 3 are similar, is the apprentice, so she would have done 750 theory, and then later the practical.
So we can make a motion because she's gone and gotten her hours that she should retest, or are we just granting her a license?
That's already tested. So what happens if an individual shows up at the school, they may or may not tell them, I did something wrong and I was revoked, right? So the school has the discretion to look at the credentials, accept them, educate them, put them to test. The students finish the exams. In many cases, they know they're going to need to be questioned by the board, but some might not. When we go to license them, we can catch that this individual had a license here. We have no authority to approve it. It has to go before you. Yeah, it would be nice if they answered the questions at the bottom. If you look on page 95 at the bottom where it says, I have held a cosmetology, manicure, shampoo, natural hairstyling instructor license in Tennessee or any other state, the answer should be yes. That would flag us to look for other things. We get the no often.
And we recently opened an administrative complaint in a similar situation, but I think the situation with that was because of the no, a license actually went out, and we were not able to catch it. And so in that case, the consequences were severe enough that we thought it was prudent to open an administrative complaint. That's why these questions are asked, so that we can make sure that we're following our guidelines. Here, she said no, but we've caught it in advance. So there haven't really been any consequences to this no. So it's really up to you all if you think this situation would merit an administrative complaint, or if we should go ahead and review this. I mean, she has gone ahead and, from Roxana's statements, attended school and tested properly. So I think that is worth some consideration.
Sometimes they don't understand our translations too. I've had some come in and you ask them, and they're still like, we really don't know. We have to translate it on the phone for them, and it takes a little bit of doing so. Whether she's doing it intentionally or not, who knows?
I guess that really is the crux of the question. Do we feel like this is an intentional misrepresentation, or an accidental checking of a wrong box on a form that might be unfamiliar? We have a few here that are similar today. Do we want to have them, we want to send them a letter, ask them to correct their form, give them a second chance on that, or deny them? I guess that's kind of where we're at.
I just want to make a statement in reference to it. When I applied for global entry for travel, international travel, there was 4 or 5 questions that, it might be heavy, but I'm just bringing it up because it reminds me of the situation, where under that question it made it very clear, if the above question is not answered correctly, or found to not have been answered correctly, this will terminate the ability to reapply. So that wasn't the one I was going to cute on. If I was going to cute, I'll say that. It kind of got my attention. It may be something for us to consider if it really puts them to an advantage to have a language barrier for that one question, and it happens more often than not, we may need to treat it different to get a different result. Just an idea.
Yeah, and I would not support support the idea of denying the applications because this is wrong simply because, in particular, this person has since gone to school and since retested. So I think that says that this person is attempting to do the right thing. I think we really have to look at them on a case-by-case basis and see what the consequences were of the misinformation they provided. Here, we don't really have any consequences. We've caught it, but it's up to you all how you want to address this issue because it is a serious issue, and people do know that when they fill out this kind of documentation, kind of what you're alluding to, Frank, these kind of questions are very important, and so the potential is there for mistakes to be made when false information is provided, whether intentionally or not. So I think you all probably need to decide how to deal with it, but I think denying an application would not be appropriate.
I agree with that as well. And the fact that she got her hours in Tennessee versus Vietnam, I think shows that she actually did the work as opposed to possibly getting moved back to Vietnam for 300 hours and came back to Tennessee.
Several of these, I would think, could be a language problem, but then we see that there shouldn't be a language problem. So,
but all the other ones weren't a language problem. When all the yeses were yes, when just a yes was a no was only one, I don't like the trend of that. Because now if you got 4 or 5 language problems, you'd probably miss more than one.
What would be the effect of administrative complaint?
You all would, legal would review it and make a recommendation, but ultimately you all would decide whether you want to do a letter of instruction, a letter of warning, or some type of financial civil penalty.
What about looking to approve it with a 2-year probation?
So this individual has met the licensing requirements from the perspective of the hours and the testing. So we normally don't do a probation. It's not say you all can't. There's just, I don't know the reason that we go that route because then in that point we've got to keep up with complaints a little bit differently. And this person could then lose their license for a simple mistake. So keep that in mind as we decide. The previous complaint that we opened administratively that Cheryl was talking about, we closed with letter of instruction. So, just a caution on when you're reading the documentation that you're attesting the importance of doing that. This today would open 4 complaints. All 4 have missed it that we're going to look at. And that's not to say that others don't miss it. The only reason it's flagged to me is because of the revocation piece.
I would be inclined to support this person for the very fact that she's done them all, and that's the deal. Is if she has the hours, she's taken the test, she's passed the test.
So you're saying you want to give her a letter of instruction in this case to be more careful?
I would not extend it to like a warning. I would just, advise them that this was reviewed. And,
I think we have 2 situations at hand. I agree with that. I don't think this was malice, so it sounds like they did the work that was necessary. But it just brings up the potential of how do we move forward by not letting us being so vulnerable to such an easy mistake, right? So is it, I'm not sure probation is the way to go, but if any of the questions are found to have been answered inaccurately, maybe a fine is in order. If that would make you, if that was kind of in the beginning of your instructions, it would make you think twice about, and I don't know if that's a legit thing to do or not, or if that's heavy, but, the thing is, if it's happening often, I think we got to look at how do we protect ourselves from not being so easily swayed by checking the wrong box and then sending a letter, it shouldn't have happened, don't let it happen again. It sounds like an easy way to skate through.
So the letter means that we would open an administrative complaint and have to have it follow all the same steps that we would for a bigger complaint, if you will, with a real citation. And it has an implied cost behind it. Every complaint we open has a cost. That's not to say that we can't do these. Today we would be opening 4 for the same thing, and even if it ends in a letter of instruction, it is time involved in the office, then the centralized complaint process, then legal has to touch it and and then the letters go out, they have to be certified, have to come back and present it again to you for closure. So it has to live that full circle.
I think there should be maybe a case-by-case decision on
I think if you were to do some type of civil penalty, it would need to be at least probably $200 for it to be feasible to move forward with administrative. Otherwise, these could be approved, if they meet the requirements, but because of the things that Roxana mentioned about the cost of opening each of these complaints, I think we just need to take that into consideration.
I don't think we have to do that with this case. I mean, I would recommend not doing it with this case, but I would look at how do we potentially protect ourselves moving forward. Roxana, have you stumbled upon this?
No. The reason, yes, we stumble upon it by the fact that they're ready to be licensed. That license really should have gone out in 2 days. That's about our turnaround. But as soon as we get it, because they've passed and did the hours, we see the history, and it was previous license revoked. The question obviously contradicts it, and as Cheryl said, the one we opened was because there was a slight effect in the name had changed completely and a digit off on the social, so we didn't catch it until other pieces were put in motion. In this case, we did, and if everything lines up correctly, as it should 99% of the time, we would catch it. And if the board's decision is, it's obvious that they checked no, it was the first question on the line and went fast. These are the questions for those, the instructors in the room that do the schooling. They realize that PSI has a certain way that the questions are presented. You could go real fast and maybe not pay attention. I'm not saying that's a good thing, but that could be what's happening. They just flew through it. So no harm was done because we caught it. Nevertheless, those are attestation questions that you're supposed to read carefully, go through, and determine for your license.
I mean, one idea may be to amend the language that's on that form, and Roxana and I would have to discuss that, but maybe in amending that, provide notice that, failure to answer them properly could result in civil penalties, etc. And then once that's there, I think you all would feel more comfortable as the board imposing financial penalties for those types of violations.
I like that suggestion.
I think that's a great recommendation.
What if it said, have you ever had a cosmetology manicure license revoked in the past? I mean, would you not put that?
We could have a separate question. The reason we just ask if they've been licensed here or anywhere else is so that we know that this person should have had a reciprocity license come in from someplace else, or maybe they hold a manicurist license and now are also getting aesthetics. And we want to look at all that history before this license goes out. So that's why it's kind of as general as it is. It asks about Tennessee as well as any other state. The vast majority haven't been revoked, thank goodness, but
I like stating the consequences up front.
Yes.
Instead of
I think that's a great recommendation.
Would the amount of the fine included in that? Because if they see the monetary amount on there,
It might not be worth that, but that might make them think it's worth $200 a license, so I can get my license. I rather think it's going to be $1,000.
And I think we would put that $0 to $1,000 on there, because I think ultimately what we would recommend could depend on facts that we don't know yet. I mean, you could have someone who only made one mistake, or somebody who we know intentionally was trying to hide some serious information. So we're more than likely include the range that we're authorized to issue civil penalties from.
Well, what do we want to do on this particular case?
I would recommend that we go ahead and allow them to be licensed, given that the education's from Tennessee, the exams have been met. I think we're okay with the 4 that I said are almost identical. Moving forward, I'm sure will help me. We'll draft language, contact PSI, and have it added to their question, because this is what they see when they check in to test. And I think that's a fantastic idea.
I'd make a motion to go with your recommendation.
I would second that.
We have a motion and a second to go with Roxanne's recommendation. All in favor say aye. Aye. Motion carries.
Is the board good continuing? Probably have another hour to an hour and a half and we'll finish business, or do we want to take a break? 10-minute break?
10-minute break.
Okay.
We'll be back in 10 minutes.
It is 11:10. We'll be back at 11:20.
Now, we've done a lot of new business, so we just
No, the directors will just... We are on the miscellaneous section and on page 99 of your iPads. So next we have a request for a manicurist license for Ms. Tran. Ms. Tran passed her practical exam in March of 2017. She previously held a license which was revoked in October of 2016 because she did not obtain her education as the requirements were stated in the Texas law. She has since then completed her hours in Tennessee in March of 2017 through the apprentice program and is now requesting her license. Ms. Nguyen follows, as we explained previously, Ms. Tran, similar to Ms. Nguyen previously, has not marked the correct information regarding a license, that being licensed in Tennessee or other states. We're going to treat it the same way once we add the PSI language and not open anything further on this. We need a motion to be able to approve her.
Make a motion to approve.
We have a motion and a second to approve with the previous recommendation. All in favor say aye.
Aye.
Motion carries.
May I ask a question?
Yes.
These that are Texas, are these go back to that same school that, okay.
Yes, we had a situation for about a year and a half that we did investigations. There were actually 9 schools in the end, and so those individuals that we licensed coming from there, once it was determined that the hours weren't correct and we had the final disposition from Texas, we used it to revoke these. Okay. Yes. Next on your iPads is a request for a Master Barber license for Brian Rashad Smith. Mr. Smith has passed his practical exam in October of 2016. He previously held a license which was revoked in April of 2014 because he did not meet the requirements in Tennessee to obtain his license. He then completed hours in January of 2016 and is now requesting his license. Mr. Smith, very similar to the previous 2 applicants, did not pay attention to that first question and marked that he has not been licensed in Tennessee. We'll follow the same parameters and not open a complaint. We would need a motion if the board is okay with issuing his license.
Make a motion to issue the license.
A second.
We have a motion and a second to issue the license with the previous recommendations. All in favor say aye.
Aye.
Motion carries.
Thank you. On our agenda, we'll go back to the reciprocity applicants. Today, the reciprocity committee met at 8:30. We reviewed 12 applications, and I will turn it over to Ms. Nina Coppinger for a recap.
Of the 12 requests for reciprocity, 4 we voted to grant reciprocity. 5 we required that they take both Tennessee exams. 1 just a practical exam because that's the only one they were missing. And then 2 we denied basically for lack of information. So we just need a motion to accept that.
I'll make a motion to accept.
Second. What's the second to accept? All in favor?
Aye.
Aye. Motion carries.
Thank you. Okay. Next on your iPads is what we're calling the Director's Report and Civil Penalties. Let me get to the right place. On page 110, you will see the breakdown, which includes at the top portion of the revenues, you will see all the way across under March. Civil penalties taken in is $22,116. Those will always run a month behind. I think we'll get used to them. But I know that at the last meeting that you all became much more efficient than we've been to me, and we no longer need to present these as closures. So as the cases are completed, civil penalties paid, all additional information gone out, we are closing them immediately. And so it's my understanding that the board still wanted to see that dollar amount, correct? Okay. So on this financial report, which is what's done for all the programs, You get to see total revenue received. It's a year-to-date, the fiscal year information, and then below are the expenses as well. If you've got questions, I might not always have the exact answer, especially if it's very specific. But in general, the good thing with this report is it gives us an idea of what, for example, will be a cost back for licenses, and that's sometimes, especially with the number of licensees in this profession, can be a substantial figure. It's at $263,535 so far for this fiscal year. And so that's an estimate, but it's based on everything that we're actually doing, instead of a surprise when we're ready to close the fiscal year. And none of this, of course, reflects the fee change. As Cheryl mentioned, that won't take into effect until at least after July 1st. And so we're building those renewals for the folks that are going out after July will include the new fees. Okay. Not really, because now that we're closing them as they come, this is going to be presented to you as information each time, and we'll be able to proceed that way. Sherelle, I think go ahead and turn it over to you for the proposed rules. You should be on page 112, and as I mentioned briefly to the complaint committee, I think Sherelle worked very hard to get a process in front of you, and I got a chance to review it, and it's fantastic to try to give us some consistency on international applicants, reciprocity, and so forth. So I will turn it over to her.
Okay, so at the last board meeting, I mentioned that we would plan on discussing this issue more at length at this particular meeting. So I went ahead and drafted what are some proposed rules related to international applicants. And just to clarify, these rules are not applicable to international applicants per se, but those educated internationally. And at the beginning of the process, the focus was on internationally educated applicants exclusively due to our concerns about ultimately trafficking. But as I started looking at our rules and what we currently have in place, I realized that we don't have our application requirements for any of our applicants in our actual rules. So this would be a great time to go ahead and put that information in our rules as well, so that it's clear to any applicant what the requirements are for an application with our board, because we do have issues that arise from time to time, and currently the only way that they can find out the application requirements is by contacting the board or actually reviewing the application itself. We have really good materials associated with our application as far as instructions, etc., but those are the steps that a person has to take to find out what documentation is actually required to apply for a license with the board. Now, if you look at page 1, examination requirements, what we thought would be a great idea to address the concern of not just internationally educated applicants, but applicants that are also purportedly educated in the United States who have not actually attended school. And we've seen that issue a lot lately, where schools are submitting people and purportedly these people attended school, but we have concerns about the legitimacy of the schools themselves here in the United States. So what we think is a good idea is to limit the number of times that people can test. The thought process being that if you attended school and you learn the material, then you should be able to pass the test within a reasonable number of attempts. So in this draft of the rule for cosmetologists and barbers, it's essentially identical. Someone would have 3 attempts to pass the appropriate exams in a 12-month period. If they utilize all 3 attempts in that 12-month period, they wouldn't be obligated to do so. After that, they would only be able to test once every 6 months, and that would be it. And the goal would be to ensure that people are not just taking the exam so much so that they become so familiar with it that they eventually pass. So we think that would cut down on the ability of those who have not attended school being able to take our exam and eventually pass it, and would ultimately address our concerns about trafficking and our concerns about just fraudulent school hours.
Is the state laws translated yet into Spanish and Vietnamese?
Well, so the reason we've never translated them is because of the cost, to be honest with you. As we know, we last year closed in the red, so the last thing I ever want to do is put us in a financial situation where that worsens it. So rules and laws are living documents. That means that they're changing on us every year. So if we start paying, and we don't have a problem with it, the board's going to have to authorize that. We will be paying to translate the rules and laws into the 2 languages possibly we need the most. There's a fee behind that, and they're going to change every year. That means that we're going to be changing every year. So when individuals ask us for it, we do the best to walk them through it. We tell them where they're available, but at this point, we've not chosen to translate them because of the cost implied. And then, how do we say to others that need them translated, no, we can't. The shop owners that the language barrier exists would have an obligation because the law tells them they must have them in hand. And so it's a conversation worth having, but that's the reason we've not done it.
Because, I've just had one of my Spanish, took in Spanish. She filled the law part and all that stuff. That's where she was lowering her scores because she said, I don't understand them. Yeah.
So for the schools, for example, that are taking on international applicants, and I understand the barrier, I'm not downplaying that. If you're using flashcards, if you're using books, if you're using programs that help you do some translating, I would imagine that the rules and laws would fall on the school to help them understand, because they're going to be in Vietnamese and Spanish for the 2 languages. But until we get to a situation where we've started to see an increase in the money and we're okay financially, then we can readdress doing that. But at this point, we're not quite there yet. So the schools kind of have that obligation, at least that's my thought, you all can debate it, to help the students that don't have the English understand, because there's 25 questions in there that are about the rules and laws, and just as important, if not more, they've got to understand them to follow them. If they're not understanding them, then let's say they pass the exam, they're not going to have a clue once they get out there. So they really do have to come out of the school understanding our codes.
I was thinking that 3 might be a little low for some of the ones that are trying to translate.
What is the average?
Below 2? That is, no, that's a good. So when PSI presents at the continuing education sessions, they actually always give their statistics, and they give them based on license type. So they'll say our master barbers are passing the first time, and that's at about 65?
68% on
the first time. Cosmetologists are a little bit higher. They're still, I think, under the 70. Estheticians always end up coming in at the highest. And they kind of go through all the numbers and present them to instructors, so instructors have an idea of what that rate is. I would imagine if we looked at the Spanish and Vietnamese exams, they're still not passing it on the first round all the time. I've been told by educators as well as the licensees that the books aren't perfect in the other languages, that they really are not as good as we would like them to be as well.
Is there a statistic that says 80 to 90% pass within?
Yeah, PSI has them. Yes, every school can obtain their own statistics. We know that,
In general, for this law, you're saying 3. So can you say that in 3 tries the majority? And that's what I'm trying to get to, the justification of why it's 3.
well, we don't ask, are you an international student, right? So now, we do know how many are testing in Spanish and Vietnamese, and we could get a statistics how many are passing those languages. But a lot, like today, half were in a variety of other languages. They weren't just in, I think we had 1 in Spanish, none, and 2 in Vietnamese, and the others are going to be looking at testing in English. So because we don't ask if you're an international student or if English isn't your first language, we just have that general statistic.
History lesson on the recommendation to limit. When I was a barber student a million years ago, if you failed on the first attempt, you actually had to go back to school for about 300 hours, 400 hours. And then test again. At that time, they gave the test 4 times a year, and once in each grand division, but a total of 4 times a year. And if you missed the first quarter, you're 6 months down the road anyway.
Right now it's unlimited.
Is it unlimited right now?
Right now, and we discussed this, we're going to see that in the next round of the contract that we have, that we add something like this to try to implement it sooner. We're going to ask that technology be used and see if our testing vendor, PSI, can block it after 3 times or what we need to do to block it. Because right now, as a regulatory board, we stay out of that piece until they pass and want a license, right? So if someone failed it, and we've seen up to 22 times, and that was an English-speaking applicant, to the high teens for some of our international folks. So we will try to put something in motion as quickly as possible if the board is comfortable with all this, to change that, and then in the contract piece, we will add it as well. There's a good chance that we have a lot that are not passing in those 3 times.
I think 3 is generous. I mean, really generous. I proctor exams for, most of them are electricians, that if they're being called to a nuclear plant for like an outage job or something, and they have to come in and study online courses about like fitness for duty and radiation and plant access and all this stuff. So they study, and then they have 2 attempts at the test. So if they fail it for the second time, they don't get the job. So they go home, and they can't take any more tests till the next, 6 months later or whatever it is. Different languages too? No, just English. Yeah, because when you're going to a nuclear plant, you're reading English. Yeah.
That's good insight. I mean, I was sitting here wondering how other industries boards handle it.
Several other industries, we've got 15 programs now that we work with all the time, and several of them have that limit. After you fail this 3rd time, you must either go before the board or petition, so it's not unique. Cheryl really looked at everything as she came up with it, so we'll have to figure out how to implement it with PSI, how to work this, and we'll see the impact.
But in your experience, does NCIS and their testing, do they address all these different languages and provide the materials for people to study in the different languages for the tests?
NCIS doesn't provide the materials to study, but they do in some states offer another language. It's on a state-by-state basis, I think, if the states...
So is PSI available in other states and languages that Tennessee would need?
Yes, that's how we customize the piece. We added the Vietnamese and the Spanish. We looked at, Texas had it very, very similar to ours, and one other had it.
So in the translation attempt of the department, to do all that.
We did, for the written as well as the practical. Every question we have out there has to be available in those 2 languages as well to be able to go through the same shuffling of random questions.
So really, that's part A of this. I can move on to part B. Part B deals with the actual documentation requirements, and as I said before, we want to make sure that while we're opening this up for internationally educated applicants, that we also go ahead and specify the application requirements for all of our applicants. I think this also helps us as far as enforcement. Sometimes, for example, with our reciprocity, 5 years, the specific documentation that needs to be provided is not, and we have to go back to the applicant and request additional documentation. And it's nice, it would be nice to have a rule showing why we're requesting specific documentation, because they'll provide what they think is 5 years, evidence of 5 years of experience, and it's not satisfactory to the board. And so it would be great to have that information in the rule. But I'll direct your attention to the first paragraph under license application requirements on the first page, and it's essentially identical under the Barber section. Essentially, we want the board to have discretion to alter the documentation requirements for good cause, because any number of fact scenarios could come up, and so this is flexible to an extent as long as there's good cause. We are requiring translations, which we currently require translations, so that one is not new, but we want proof that those translations are valid. We looked into the credential evaluation agencies, and those are the agencies that vet the international documents and determine whether or not they are in fact legitimate. And the company that we determined would be the ideal company to use, because they focus on licensure and specifically they're experts at the cosmetology and barbering industry, vetting those documents. We spoke with them and learned that their costs are much more than we anticipated, so it appears that for the average applicant, they would be looking at about $500 for a credential evaluation, and we made a determination that we did not think that would be appropriate for every internationally educated person to have to pay that large expense. And so in these rules, and we've discussed this, we want the executive director to have the discretion to request a credential evaluation report. So applicants would submit the prerequisite documents, and depending upon any number of factors, we have numerous reasons, from Roxana's, from where she sits, why certain schools and certain things cause serious concerns. And so she would have the authority as executive director to order these credential evaluation reports on a case-by-case basis, and she'd be able to make those determinations rather than doing a blanket requirement that would cost every applicant hundreds of dollars. We just thought that would be potentially prohibitive for a lot of people, and wouldn't serve our ultimate goals, which is to address the issue and protect the public.
I think Sherelle's covered it. We've seen it. Anytime I have a concern, I bring it before the board. Usually it's that another state has flagged us of something. A lot of times the states will even say, well, the school is okay, they're licensed now, but we have concerns, no proof. Well, that would be grounds for us to be able to ask for some of this. Or we'll hear through either phone calls that, those documents aren't real. We have, and as we look into things, we have that idea that it really isn't. Those would be the individuals, I think, that we would send for this type of evaluation.
We wanted to get your thoughts on this as we try to move forward, next steps. Do you all have any thoughts on these, comments, questions, or suggestions?
We've had some of those cases where it just felt like this one we should go deeper on, with some paperwork and that kind of thing. And it's so hard to case by case them too, with some days we're on a roll, and and some days like there's not as many, you look into it. So I love the idea of it being that methodical, and the fact that it certainly went deep. I think it's awesome.
Cheryl has done fantastic on this. One of the things that we can ask, as she says, the translated documents they're giving us. But for the most part, every embassy will do their best to help their residents, leave their country with good documents. I can attest to that. My documents were all translated and stamped and had all those things. So those are the kind of things that may add a little bit to everyone, but for the most part, at least half of our international applicants are presenting those documents. I take them off, so your iPad presentation is in hundreds of pages, but we actually see them for many of our international applicants. They're all coming from the embassy translated, and so you've got it in both languages. So I across the board, those are the things we're going to be asking for. Yeah.
International students, we're asking for U.S. passports and of course, some type of immigration documents, I guess.
Well, let me interject. So on the international, because at this point they're not licensed in the U.S. or U.S. territory, they don't come in through reciprocity. So we're evaluating what they have. Many of them will provide a passport, but at that point, we really don't question that. When we're ready to license, we have, for the safe verification requirements, we there have to know if they're a U.S. citizen or qualified alien. That's the piece at which. Anytime we're on the phone with an individual, if they ask about immigration status, we're very upfront, point them to the form, because it isn't something that we regulate, but we can't license them without it. So we'll have the conversation, but we generally don't get those documents this early in the game.
Let's think about that eligibility document.
That is actually for licensure, business license or individual. So it is sad if someone's gone through everything and then missed that piece and gets to the end and we can't license them because of it. It's out on the web, and my hope is always that the schools touch in on it, obviously if they're teaching, but because it isn't part of the testing piece, we don't get to know some of that till the end.
To that point, Arch, how much of that work is done and then you find out they're not eligible at the end? It seems like the work's being done up front and you have that potential risk of they don't qualify. Wouldn't that be the first qualifier?
And we can add that verification eligibility on the application test. That I agree with you. I think it makes sense. We don't need it at that point, but I think it's only right to have them tell us and give us the, visa, if you're a qualified alien, you need 2 documents. The list is long. They need to have 2 of those.
If that's a deal breaker, it sounds like we're putting cart before the horse.
Yes. And any applicant, interesting enough, we denied few, thank goodness. It's mostly in our profession because we are very international and diverse. And so it is very hard because we have to point back to immigration and say there's nothing we can do. Here it is. But until the schools were aware of how it worked, we've had schools with just a tough ethical dilemma because they didn't quite explain the whole picture. They can take a student on and educate them. There's nothing that says you can't. But then that carrot at the end of the light, which is the license, we can't give them. So I agree with you. I think with this process, we can change it, and that application test automatically includes it. We know we don't need it until licensure, but we have it up front. It's a great point. Yep.
Easy to do.
Yeah. Very easy to do.
Well, are you looking for other recommendations here, or is this something that we need to think about and look at and bring back to?
Well, I think this is a good foundation from what you all are saying. I would like for you all to look at it and come back to the next meeting with any suggestions or ideas, and I'd like to work with Roxana as executive director and others in legal to try to make it better before we actually start moving forward with it as actual rules, because it's really important that we have a very polished set of rules that does what we want it to do. And I think just like the change we just made now to add that verification at the beginning, things like that that we think of and catch at the beginning will make this process much smoother with rulemaking. So if you all could look at it and we can discuss it again at the next meeting, I will work with the rest of legal and Roxana to think of ways to make this better.
You send us any copy of it?
I will email that to you tonight. So
Official rules that we would adopt.
Yes, ultimately, this is like a rough draft of rules that we'd eventually adopt, and so that's the direction we're moving towards.
I just had one thought when I was looking at the requirement to have a certified high school transcript or GED. Do you think you should include the high set, GED or high set? Because didn't the high set replace the GED?
It's not a replacement. It's an electronic way to take the GED, and it came through the Department of Labor. So if they're coming from the United States, the high set is out there. If they're coming from another country, it doesn't exist.
Oh, okay. I don't know if you need to add that or not.
You could put or an equivalent of, because obviously they'll have their own GED version.
Right.
Yeah, I think that's good. So I will email, if it isn't tonight, definitely tomorrow, everyone, this full document, and you're welcome to reply with any thoughts, ideas, concerns.
Okay, with this, with what we were discussing earlier, where people are saying no to that first question, could that also be added into this?
I think what they're doing is already in the rules. You know, it's a misrepresentation, intentional or not. So I don't think that's something we would add in here. I think it's something, you know, we've decided we're going to change that language, and then from you know, a policy standpoint, when that notice is out there, the board will move forward with, you know, determining what the civil penalty or appropriate disciplinary action needs to be. But I think it's already essentially in the rules that you can't be dishonest, you know, with the board, whether it's intentional or, you know, not. And so I don't think that would go and be a part of these particular rules.
In June, we'll put this back on the agenda with any changes you have, other items that Cheryl comes up with, and we will vote on it at that point. Does that sound good? Awesome. Yes. Thank you, Cheryl. One of the last items we've got on your iPad is the 2017 approved continuing education sessions. I passed around the list of the 6 classes that we have so far, and if I could read them out, this will be the official person that's approved by the board to attend these. If we need to make any changes, we can discuss these at this point. We have the session in Memphis that is scheduled for June 11th and 12th. Ms. Wivette Granger will be attending that. The session at the University of Tennessee Conference Center is on July 23rd and 24th. Ms. Nina Coppinger will be attending that. The one at Tennessee State University here in Nashville on August the 13th and 14th. Mr. Ron Gillihan will be attending that. The 2 last sessions in Memphis, the Educators Seminar in Ms. Granger, I've got you for both. Will you be doing the June and the October? Okay. There's a June 26th and 27th and October 22nd and 23rd. And we have 2 other Memphis board members if you'd like to do either of those. Which one? Okay. For the Educators Success Seminar? Okay, I'll pass this back around for you to pick a date, and then Ms. Granger can go on the other one. And the other one in Memphis is the Professional Business Consultants. That is on June 24th and 25th, and Ms. Granger saw that they were empty, not signed up for, so she selected them. I'll let that one go back around so Mr. Fingers can pick one. And based on those, PSI is going to be sending their main contact person that we work with, Lynn Thomas, and then 2 other representatives to every continuing education session this time because our practical exam is being revamped and come up to the times, and it's going to be just a phenomenal change, and we want to make sure to reach out to all the instructors. And so one of those sessions we're also going to videotape and put on our website and PSI, so those instructors that don't need the continuing education this session still are well aware of the practical new version and should be very excited by it.
When will that change come into effect?
Probably not till the end of the year. We need to make sure to reach everybody. The goal is for it to be very successful as opposed to be in a hurry. The theory exam bulletins have all been changed. So if your students or the schools have old bulletins, you need to get rid of them. On the PSI, they include all the change questions and so forth and a new date because the theories have been loaded already. It's the practical. I plan on attending as many of these as possible, and Glenn will be attending some as well to make sure that we go over the new laws, everything. Yes.
I can see it in his face.
He has done phenomenal. Remember, it's 15 programs, not just so you can imagine. So I'll pass this back around so Ms. Granger and Mr. Fingers can decide which of the sessions make sense. And then the last items that I wanted to talk about is not on the iPad. This is just a reminder. The rules that have gone into effect, and we worked on them for a very long time. We called them the shop changes, school changes, and then the fees. Those are now loaded on the website. So if you look on our main website under tn.gov and then under business or government, you find regulatory boards, cosmetology, barber page. On the left-hand side, when you open rules and laws, you'll see new. When you open them, what we did for the ease of the shop owners and licensees on the right-hand side, they're called fees, shops, or schools. And so that adds the dual licenses for the shops under the shop piece and talks about it. The schools is the piece I want to talk to you about, and then the fees we mentioned. After July 1st, they will start going out. So the piece on the schools, we've already started getting calls about, and I need the board's guidance on how you want to see these. So the rule, and Sherelle will help me if I misdo anything, works both ways. This is what we've called the crossover of hours, if you remember, and we talked about it on the rulemaking committee or subcommittee that we had and debated what should we do. So I'm going to read the piece from the cosmetology over to the barber. It works both ways, given our numbers. Maybe I'll read it the other way around. Here we go. So under the statute of 0440-01-.03, Section 5 on the curriculum, and then the barbers is 0200-01-.13, Section 1. Again, that 750 hour that used to be is being crossed out and being replaced by the 300. So it says that the applicant, the board may approve the applicant to test, so they're going to have to take both exams either way. If they complete 300 hours of cosmetology school hours at a licensed cosmetology school, learning the fundamentals of cosmetology technique and pedicuring, this student will be given credit for the remaining 1,200 hours. So only 300. That's A. Or held a Master Barber Certificate of Registration in Tennessee or another jurisdiction with reciprocity with Tennessee for 5 continuous years. And it works the same on the other direction, right? If you're a barber and you're wanting the cosmetology. So my question is, we already have a couple dozen people ready for this exemption. And we want to know what to present you if, in fact, this individual has been licensed for at least 5 continuous years. The continuous is going to be very important. If they're coming from another state, that's a little bit hard. We don't know often when it's continuous. Depending on the state, they may just make it valid again and we not see that they skipped 2 years. So we'll do the best. They're going to have to provide us with that proof of continuous. Is there anything else? Because the board, if I recall, wanted to see these on a case-by-case basis. We will do the vetting. The office will make sure that the individual that's wanting the crossover has had a license in another state or in Tennessee for more than 5 years. And what other experience do you want to see? Or is experience, because we're getting letters that say, I am experienced in doing it.
One of the questions I guess I would have is how are we going to have them apply? Is it just going to be a letter or is it going to be an official application?
My goal was, since June is almost here, to do an actual form. Our applications have to be blessed, so if we can get them blessed, it won't be by you all because it'll be right in time for the meeting, and I don't want to delay them till August because we have no June meeting, or July meeting. So we were going to do a form with these basics. Yes, I've decided to not take the 300 hours because I have experience. I've been licensed for 5 years in such and such place. Give us the basic information, and Sherelle will look at it with me so that we're asking the questions that are relevant to what the law allows us to look at. So you'll have it in writing why we would be waiving the 300 hours in lieu of their experience.
And I think in the direction that we're going with the new rules, most obvious to me, they would need to provide a certification of licensure showing that they've been licensed for 5 continuous years. So if they've been licensed, if that covers 2 or 3 states, depending on how much they move, they need to provide certification of licensure from those states and give it to us to look at and consider. That would be my recommendation to you all.
Considering proof of licensure, like working on the
Proof of licensure probably, just like for our reciprocal applicants, would need to be the state's certification. So
the cost of that?
It varies. Some states for our certifications $50, and some are a little bit more. That's the low end, but it's not a huge need, obviously.
Or office, or a combination of your office or another state
in with the application.
Yes, whatever this form is going to look like that's going to ask for their main information, just so we don't have, loose letters, give us their license in Tennessee, all that, and then if they're not going to school, they can say, instead of the 500 hours, here is my certification from 2-3 different states. I've been licensed in New Jersey, I'm just making up New Jersey, but which allows me to do barbering, and it's a dual license.
I think we would need to have something that would state if they are licensed in another state, because they could have some licensure issue. Does? Would that affect their license here?
Especially from Jersey.
In terms of I'm not sure that we can look at that. It looks like the only thing we can look at is whether it's been 5 continuous years. So, of course, if there's been a gap, if they've let something expire, if maybe they took a year off, in the past 5 years, those are the kind of things we can look at, but I don't think we can look at necessarily any disciplinary action taken at this stage of allowing them to test,
If they've been revoked in another state, it would show when you receive their certification.
Yeah, that should show, and that would probably impact their 5 continuous years.
Absolutely. Yes, that's a very good point.
I'm just curious. I've had lots and lots of people ask me about this.
Well, and I
told them I had no idea.
I think here's what's confusing them, because, hopefully starting this week I'll be here the full day and be able to handle some of these, but I want our team to walk everybody through the correct path. Folks are reading this and thinking, I'm a licensed master barber for 10 years. I can apply for this. And that's not necessarily the case. If you are a master barber and want to apply for this, then we're going to have all our barbers applying for this.
They're applying to test, correct?
To test, yes. And is the question, are we going to, now if they're coming from another state, that might be easier because they may have the dual license already. But if they're a master barber in Tennessee for 10 years, they're applying to get this cosmetology license 5 years, but they could be much way past that. So it's continuous, and it's 5, 7, 10, whatever. We're going to be waiving the 300 hours in lieu of their experience, but it says hold a master barber registration in Tennessee or in another jurisdiction. In Tennessee, they weren't allowed to do some things or might have not learned some things. Now, the test will take care of it if they really don't know how to do it. Pedicuring, for example.
I mean, I can just speak from my personal experience, which is I employed a master barber for several years. She no longer works for me. She'd gone to barber school in Murfreesboro, maybe, and she was at that point, the school that she attended absolutely taught pedicuring. And so, again, she no longer works for me. If she sent in a letter and said, I'd like to test for my cosmetology license, I would feel like she has the test will prove, right, if she can do it or not and understands it, but at that point she had received education in it.
But this says or. It's either the 300-hour route or test out.
The instructor's license, will they transfer over from one to the other?
This isn't dealing with the instructors. This is the crossover within disciplines. Cosmetology to barber, barber to cosmetology.
So I get lots of questions about whether any of these folks need to cut, like this, for example, this woman, I have not spoken to her about this, but she's a great candidate who would be interested in a cosmetology license potentially. Would she need to come before us? I'm getting that question a lot.
At the last time we had the committee, the rulemaking committee that dealt with this, the board had wanted to see them on a case by case. I want to make sure we know we're talking about a lot of people.
But can we not let you make a decision upon the experience if it's cut and dry?
I had emailed Roxana a while back when we knew this was finished. Folks, I can be the first case. You can throw whatever you want to at me, and let me be the test, if you will. I'll do whatever you want to do.
You need your cosmetology license, Ron?
Well, are you kidding me? Why not? That's what Roxana's talking about.
I think it's awesome.
So, that's, what questions you want to ask,
And I think that's one of the questions. If I'm remembering our committee meetings, it was, do we just want to open this to the potential 2,500 barbers and 40,000 cosmetologists to cross over? I mean, obviously they won't all have the years, but many will. And that's okay if that's what the board wants. Or in our questions, we ask, how are you qualified to do this experience? Something along those lines. And we'll come up with, I guess, the best questions we can ask. At that point, the board thought, we want to see it on a case-by-case basis, but we might have 20 to 30 people here.
I think we need a line criteria so that the administration can really do it and
sort this out.
Sort down. And if there's when they reach a line, then we can't make that decision. So do we need to determine that? Or
decision if it's cut dry. If there's any questions, you can bring it before the board.
I've got an employee who got licensed in Georgia as a cosmetologist. I asked her why she didn't go to barber school. She said there wasn't any barber school anywhere near where she's from, rural Georgia. I said, well, and then she goes, I immediately started apprenticing for a master barber in Georgia. And I didn't even know that. And I said, oh, I had no idea that you had that experience. And she goes, I would love, and many of my employees have looked at the 300-hour program and have asked a lot of questions about what does experience mean, and I think they would love the opportunity to take the test.
Make a motion for Roxanna and the staff to decide instead of bringing it in front of us, case by case.
Well, in your form, if they check all the boxes and it's clear on their end, then you should make that decision. But if there's a box that's not checked or brings upon a question, then we should see them. Should that be all?
Also need to consider any disciplinary action against these other licenses, especially in other jurisdictions. I think that needs to be considered. This doesn't say shall, they may appear and you all may approve them. So I think one of the factors, if you're going to let people through, is what status, was their license in with other jurisdictions.
Was it in good standing?
Was it in good standing? What kind of disciplinary action was taken against them during those 5 years? Those are things that relevant.
Probation.
Under probation. I mean, this isn't something that's meant to just allow everyone who wants one to get one. I think you all have to also look at some things to make sure that good people who have followed, the appropriate rules are being allowed to test. Let's say someone has a license in another jurisdiction and they've had 3 huge cases against them in that state with horrible violations. You don't want those kinds of cases slipping through the cracks. In my opinion.
Some people, I can go to people's houses and do hair if they're ill, right? See, this is what I mean. We keep putting the heat on the people that want to do it right, and we're taking the heat off the people I didn't mean I told you. I'm just saying.
I understand.
I agree 100% with what you're saying. Matter of fact, with any strikes against you, it should be as easy to go forward. But it just continues to baffle me how we want to do it right one minute, and then we're forced to not allow ourselves to do it right coming down from the top.
Are we talking on our list? Are we talking about things like verifying whether they're currently licensed, if their license is active and valid? Is it that kind of stuff we're looking at here for your list? Or
for reciprocity, it would definitely be, as Cheryl mentioned, a certificate of registration would be that state certificate. They will have to provide that. It'll be interesting to see. So far, most of our calls haven't been those that in their other state were allowed to do this. I think we were thinking along those lines when we had so many conversations. It's our Tennessee residents that, like yourself, have probably been in the industry a long time, taught it, touched it, know that if you had the opportunity to test, you'd be perfectly fine. Yep. I've got some notes on the questions to put on the form. Glenn and I will actually probably work on this as quickly as we can. If the board's okay, I'll make sure that, obviously, Sherelle's going to review it to make sure if we don't have jurisdiction to deny based on how this is written, there may be no reason to really ask. The disciplinary history, the good thing is if we have a certification from a state, it's going to be on there.
And thank goodness we don't have many of those. When someone applies for reciprocity, it's rare that we get that. But that option's there. For our internal folks that are applying, that disciplinary history will be interesting because there we will definitely see it. So that might limit them completely, or does the board want to see those on a case by case? You know, if it's somebody that owns a shop, was a manager and was cited, you know, where does that fall?
And I would say, just looking at the rules, it appears there's definitely some discretion to deny. So, you know, as a board, you all are going to have to determine, you know, how this is actually going to work when these other factors come into play.
And something to keep in mind that I had 2 calls on and recommended that they wait a little bit was the interest in opening a school to do the 300 hours crossover. And so I said, why don't you wait till this gets out there and then kind of decide, put in your application. If almost all are wanting to waive it based on experience, you know, you hate to see a school go to that type of an expense to do this. Those schools that are asking for the 750 hours need to stop effective June 7th. And so, you know, the rules are out there, and we'll send as much information as possible, but it isn't always easy to reach all 100 schools.
I think the demand, I mean, I can't speak for everyone, but the demand that I've seen in Nashville so far for the 300-hour course, I don't know if you've been getting calls already. I mean, people are excited. I mean, that's what I've experienced. They've had a lot of questions and are super stoked about this.
I think it'll sort of promote licensure as well, with people coming over to the dual. Yeah.
Is it written right now with provisions that we can deny someone? Because there's no point in having them come before us if we can't or are not going to.
It says in here that they may appear before the board and the board may approve them, and so that's discretionary language. So you're not obligated to approve everyone that meets these requirements, but you have to have some kind of justification if you're not approving somebody why. And the example I brought up is someone with a horrible disciplinary history, you know, in their license. That would be something, an example of why you might deny somebody this opportunity.
I have a question that would be really for the office staff, because schools now are the ones who certify graduates for their PSI exams. So who would be responsible for how would we direct someone who just contacts the office for the crossover? How do they get registered with PSI? Is that something you guys would do?
We would have to pick that up, yes. We would consider it just like an international applicant, someone that didn't go to a school in Tennessee, and we need to approve them to put them through the test. Otherwise, as you well know, no one can just sign up to test with PSI. We would be putting them through. So instead of that application and test that lives out on the website, this will be kind of an application for a crossover license, dual license, whatever we want to call it. We'll cite the statute, we'll put a copy so they can read it, we'll work on that form, and then they will actually be putting in the same information as our others in many cases, so we can put them into PSI. If they're already licensed with us, we've got the social date of birth. We can skip some of that high school information. This is about the experience. We'll put them through then to test. And the other question we've not touched on is, can they test for a limited number of times? Because this doesn't say to limit it, it's just something for everyone to think about. If you have someone that's waived the hours, right, and maybe needed to take them to safeguard the public, and they failed 5 times, we won't know about it.
Well, Sherelle had some good recommendations on the previous. Maybe that should.
I mean, in theory, if these new rules were in effect, they would apply to them, because it says an applicant deemed eligible to sit for an examination. So this rule would even cover this situation. But for the time being, I don't think we have anything in place that would limit them now. You know, if we're going to start looking at these next month, assuming people get us their documentation, etc., we don't have anything in place right now.
It's no different if you went to cosmetology school and you're going to take it.
Right.
So if you've been approved to test, you can now take it no matter what, 25 times.
And within 3 years. You must pass both within 3 years. That's your only limit right now. Yeah.
years, we congratulated the gentleman on passing because of his tenacity. I think I remember
After
that.
you do it so many times, like Sherelle was saying, you kind of get the answer. Yeah.
But it doesn't give you the right answer, right? It's
Different test. It's a process of elimination after that.
I know all the versions. Counting cards.
Will they pay for this online, or is this something immediately they'll probably have to
There's right now, there's no fee to us at all. They would be applying directly with PSI once we put them in. So really, if they're not doing it at school, to apply through the office, since it's more work for y'all. Right? I don't see where we can charge a fee unless Sherelle finds a way.
I right now don't know of a way that we can charge a fee.
They'll be paying for the license.
Can we just take cash?
Is it a reciprocity? No, because these individuals, license. It's a new license, so they'll pay for the new license. That will be $60 for everybody real soon, and so that's what they'll be paying. This will be additional legwork in advance of to get them ready to go and test, but we do that with our international applicants and so forth. We will treat that very similar.
And one thing you all might want to consider if you want to give Roxana the authority to approve some of these is, maybe you give her authority to approve those with no, license history or no negative history in the last however many years, but then the ones that have, history, that's more recent or more serious, maybe those come before the board. I mean, that's just a suggestion.
If that motion then for her to approve on the ones without history, and then the rest of them come before us by case by case?
I think we can. I've made some notes. We are going to create a new form that will be similar to the application test, because that's what these individuals are going to be asking, to go ahead and waive the hours and go in the test. So it'll imitate that to some extent. On it, we will ask specifically for disciplinary issues in Tennessee or any other jurisdiction. If your license in that other discipline is from another jurisdiction, I think is the way it's referred to, registration in Tennessee or another jurisdiction. If your license is from another jurisdiction, we must have a current certification from them that has no disciplinary history information, and then, explain to us what your experience is in. I think we kind of need a body of text that says, what have you been doing to show proof of experience? If we ask for tax records, that does us no good, because they are going to have tax records in the field that they do, whatever that is. And so I think just a statement that says, similar to the examples Ms. Taxley gave of an individual that did learn some and apprenticed in Georgia and worked mostly surrounded with other barbers and watched, or that would be their experience.
And I think the light bulb's just coming on for me with that, as far as Roxana's point, because you do have some discretion to deny. If someone just had their master barber certification and they haven't gotten any experience at all, I think what I'm realizing from Roxana's statement is, you all may wish to deny someone who's just held their license and not actually worked for the last, 5 years. And so, I mean, is that kind of what you were getting at?
Yes.
Okay. And so I think that's another relevant piece, not just their disciplinary history, but what experience have they had in the last 5 years? And I think that's what the questions that she's going to ask them, they're going to get at that. Because, you are potentially giving someone a new license that they're not entitled to. And so you want to look at all those factors.
It's really tricky, though. It's so ambiguous, experience. Like, I slept at a Holiday Inn Express last night,
Let's say someone got licensed 6 years ago and they worked for 1 year, but they've spent the last 5 totally outside of the profession. You all would have the ability upon them disclosing that information to say, well, we have discretion to deny here, and we don't really want somebody who hasn't, coming in under this 5-year, provision, who has not.
I would agree. It can't be a golden ticket for anybody just wants to change their job again.
Or see kind of a resume.
Essentially. And I think that's what Roxana's getting at. At first, it wasn't crystal clear, but now I get that.
They've talked to me, and people have been doing hair for a long time. I did the crossover in either direction. Several on our list, John, who can do a license. I think a lot of the folks that are on our list are that border, 7, 8 years, and they just saw this, heard about it, want it. So our form's going to need to specifically ask for this. What identifies your experience uniquely enough to cross to the other discipline? Explain and put in the resume form or something. Because that's sort of what we have to hear and read. And then at that point, if it's vague and I'm not certain, I wouldn't have the authority to deny it. It would come before the board. If it's obvious, and we heard examples of individuals that have worked strictly in shops that are mostly male-driven and thought they could shave, all those things coming from a state where they were allowed to shave, those are like a gimme. I mean, you can just see it, and they shouldn't have a problem passing the exam because that's what they've seen. That's the clientele they worked with.
Some people look good on paper, but I guess the telltale will be if they pass the exam.
And what we can do, I think I'm going to need to do this, is ask for get statistics from PSI and everyone that we submit. And I can promise the board then to update you, 6 months, 3 months down the road when this goes into effect, of those that we put through, where do we stand? Because I'd be interested in seeing,
Here's a question that goes back to the various states. For instance, I'm licensed in Georgia. You mentioned Georgia. So if a person is dually licensed in other states, multiple licenses, you want to get a certification from each one of those states? Is that what you're saying? Or
just the past 5 years?
For reciprocity, we do for the concern of disciplinary history. So what happens when you get a certification from Georgia, it'll say approved by reciprocity. Well, that flags us, and we can't move further. We need the one. So this would be, I think, the same thing. This is telling me you had another license somewhere. We need it, and it has the domino effect because you could have had disciplinary history in Maryland or New York. And so it might not be fast for those that have worked in many states, but they very likely are the ones that will be approved because they probably have that diverse experience working in states that let them do some of these things. So we will need a motion, and, again, I'm going to work on the form with Glenn. We're going to get it to Sherelle, get all of our insights, and then the board's okay. Mr. Gillihan will look at the questions coming from a perspective of shop owner, school owner, license, knowing kind of what the board wants. We will perfect it the best we can for the June group, and then the board will get to see it. If we have more improvements, we'll definitely keep working at it. It's going to get a number of its own and go through general services and that approval process so that by August, hopefully, it's perfected. But those folks that don't want to wait till August, if the board's okay, we'll start them in the pipeline, letting them know that, this is our first month looking at this. And if we're in doubt, we'll present them all at the meeting.
We have a motion?
Motion
to approve the list as we've discussed it to this point. And we have a second. All in favor, say aye. Aye. Motion carries.
And Ms. Charlton, I will get that document to you as well. I apologize not knowing that you were going to be teleconferenced in today. I didn't get you some of the things you needed, so I apologize for that, and we'll make sure that you have them tonight. Thank you for participating.
Okay, thank you.
That is all that I have.
Real quickly, 2 more things. We've got an opinion from the Attorney General.
Yes. We distributed that for everyone to take home to read. This is what the board had requested. We debated this many, many, many months ago. Microblading, microneedling. The office has been called, obviously, just nonstop about it. So it was very good to get that letter. It went directly to Chair Ron Gillihan and then the board office. Sherelle did, again, a fantastic job. She's done questions and answers pertaining to that are fantastic because as they keep asking, you almost hate to just point to the decision because that doesn't answer everything the individuals interested really want. So, but in case you need it that way, will this be publicized? I think we have it, yes, we have it out there on the web already. The questions and answers, I don't remember if we've loaded them yet. If we haven't, they will be this week. Just the frequently asked questions, we're going to add pieces that cover this.
One last thing, Roxanna, we know for you guys, Lynn, what a great job y'all do in the office. And, you know, sometimes we'll get a phone call or somebody calls to you guys to complain about something. I didn't get this piece of information, that paper, our licensees, I'm speaking out in the public. And we know what a great job you guys really do. But I have, at my school, received a number of calls recently about one of our staff members, and I wanted to mention it here to all the board members. I have received probably half a dozen calls regarding Miss Betty DeMonbury here, and what a great job she's been doing helping shop owners in schools, and just to let you know that they're calling and saying things to me. I've mentioned it to the staff before, but I want to tell you in front of everybody that what you're doing is being recognized and appreciated. Do we have anything else to come before the board? Do we have a motion?
Make a motion to adjourn.
Do we have a motion to adjourn? Do we have a second?
Second.
All in favor, say aye. Aye. Motion carries.
That's always the loudest eye of the day.
Usually
You all drive safe, huh?